Welcome to another Voir dire to verdict. This will be a series of probably 3, potentially 4 videos. Today, we're taking a look at the beginning of jury selection in a case that's drawn a lot of attention due to the number and nature of the charges involved. Before any evidence is presented and before any witnesses take the stand, the court must first select a group of jurors who will ultimately decide the outcome of this trial. Jury selection, and voir dire, is one of the most important stages in any criminal proceeding. It's the point where attorneys and the court work to ensure that the people chosen to hear the case can do so fairly, objectively, and without bias. The process may not always be the most dramatic part of the trial, but it often provides the first glimpse into the issues that will be central to the case. Before we begin, I need to give a serious content warning. This case involves allegations of violence, strangulation, torture, and other forms of severe abuse. Some of the details discussed through these proceedings might be upsetting or distressing for some viewers. So if this one's not for you, please take care of yourself first and click off now, because this is not an easy case at all. The defendant in this case faces 18 criminal counts, including allegations that the prosecutors describe as extremely serious and deeply disturbing. As always, these remain allegations, and the defendant is presumed innocent unless and until proven guilty in a court of law. The burden remains entirely on the prosecution to prove each charge beyond a reasonable doubt. Today, we'll be following the jury selection process and examining how the court approaches a case involving allegations of this magnitude. While we won't be discussing evidence in detail at this stage, the charges alone suggest that the jurors selected in this case will ultimately be asked to consider some very difficult and very emotionally challenging testimony. So without any further delay, let's take a look at how jury selection unfolded and get right into it.
This is docket 25-1892 People of the State of Michigan versus Enrico Ramon Brooks. Counsel, your appearance for the record.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, public defender, appearing on behalf of the defendant. And should I introduce? You know me.
Yes, we'll wait for that until after the jury comes in. I don't think he's going to be speaking today. Is that correct?
That is correct, and nor is this Mr. Brooks.
Yeah, it's not him.
Oh, and who? Oh, this is. Or we're waiting for counsel for this. So we don't need your client.
I think we would. I was very confused.
Yes, we need your client to proceed with making our record. We're waiting for his attorney, so I can just swap them or bring them both out and see if we could have this one at the podium, whatever you prefer.
Your Honor, it's your call. Whatever you prefer is what we will do for you.
If it saves you some time, counsel and his client can come up here and then he can just remain. Hopefully his attorney will show up.
We'll just buzz us off, Your Honor.
Whatever you like.
We got some in for a second.
Mr. Brooks, I just called your case and counsel with their appearances on the record. As I was saying, he's not going to, I don't need to swear him at this point because there's nothing for you, either counsel's going to address that he needs to address, correct?
That's correct.
All right. This morning we had an opportunity to speak, review the jury instructions, and there were a couple of issues. Who would like to make the record?
I want Mr. Freeman to make that record.
Mr. Freeman.
Yes, Your Honor. Thank you very much. I indicated to the court and to counsel that I was concerned about the language in counts 2, 3, 4, and 5. As currently stated, it says assault with the intent to do great bodily harm, less than murder, or by strangulation. My argument is that assault GBH and strangulation suffocation are 2 separate crimes. They ought not be blended together, the title of one with the body of the second. I think it's terribly prejudicial against the defendant if the court, particularly with the court in different counts, talks about great bodily harm, less than murder. It's an exaggeration to the extent that they're not going to deliberate as to assault GBH other than the one count that Mr. Pfeiffer pointed out. And so I think it's misleading, I think it's prejudicial, and I would much prefer if the charge read assault by strangulation or suffocation. Thank you.
Counsel?
Your Honor, the statute is the statute. Statute 750.84 lists a single crime that can be committed in multiple ways. Those ways being assault with intent to do great bodily harm, less than murder, and also assault by strangulation or suffocation. They're not two separate crimes. And while it might make my job easier if there are two separate crimes, it's not something that can be changed, that we can change. I think we agreed to change the general language when the court reads the general charges before the information, I think in during instruction 1.5, but it is not anything that we can legally change because legally he is charged with 4 different counts of assault with intent to do great bodily harm, less than murder, or by strangulation.
Thank you. Anything further?
Just to say that I do not believe the statute isn't, the wording of it does not represent, in my judgment, the idea of either or. I believe the prosecutor has to select which and then charge accordingly.
Your Honor,
Yes.
count 4 is literally charged either or.
Thank you. The way the statute reads, and I would agree with defense counsel that some statutes have a small A, B, C, D, etc., because you do make choices. Although it's under the greater PAC code, there are choices. This one does not do that. However, the compromise that I am willing to make, and that I believe we agreed to, is that I will read the information as written. I do believe that it comports with the intent of the statute by the legislature. And furthermore, just to make that record, that even though, for example, count 2, assault with intent to do great bodily harm, less than murder, or by strangulation, does not address the element of murder, it does talk about the elements did make an assault upon Melissa Clark by strangulation or suffocation. So with each of these counts, by their listing and specificity in accordance with the notice provisions in our state and statutes, the felony information does comport with the legislative intent and how it is structured specifically under these variations of charges. The compromise, however, is when I read Michigan Criminal Jury Instruction 1.5, introduction of judge, parties, counsel, and witnesses, and it talks about this is a criminal case involving the charges of. What I will do is specify count 2, assault by strangulation or suffocation. Count 3, assault by strangulation or suffocation. Count 4, assault with intent to do great bodily harm, less than murder, or by strangulation. And count 5, assault with intent to do great bodily harm, less than murder. That is the abbreviated version, comports with the defense counsel's request, and I think we meet then the requirements. The jury instructions are simply to inform the jury. They will have to be read the full felony information, and then at the close of the case, you'll be arguing and they will be receiving instructions in the final jury instructions as well that will comport with the statute. What you've raised, counsel, I think is a good issue to raise, but those are both legislative issues and perhaps appellate issues. So I will leave it placed where it should be, but this compromise, I think, meets with the objectives, at least in part.
My thanks to the court.
Thank you.
Thank you, Your Honor.
I understand there is a stipulation for sequestration of witnesses.
Yes, Your Honor.
Yes, Your Honor.
Furthermore, in compliance with the jurors' right to be private, first of all, there's no cameras that will be on the jurors. Second, I have the list that is unredacted for your review. I understand both counsel have reviewed the unredacted list. However, at counsel table, you have the redacted list. If at any time you wish to review the names of the jurors again, please approach and I will certainly give that to you. But for everyone's comfort level and safety, we only leave the redacted jury list with counsel. Is there any objection to proceeding in that way? And have you had an opportunity to review the list? And please thoroughly, and I'll remind you because I know this is compound, are there any objections at this point to any of the proposed jurors?
Your Honor, the people have had a chance to review the unredacted list. I don't recognize any names. Detective Brandman potentially recognizes one, but even if it is the same person, she doesn't believe that person knows her. So if When the normal question is asked, does anyone here know these people, the witnesses, Secretary Brandon's name will be said. And if he does know her, he can raise his hand. But we don't believe this going to be an issue yet.
Thank you. Counsel?
Thank you, Your Honor. Yes, I had an opportunity to review the unredacted list. I saw several last names that caught my eye, but the first names didn't match with the people I know. So I don't know, it could be a son or daughter or something, but I don't think it's going to be an issue. I did not recognize anyone on that list with respect to the first and last names listed. Thank you.
Thank you. Furthermore, I'm going to do what I normally do, which is as I read this, when I get to this reading of the 18 counts, I'm going to begin the questioning so that by the time you, as counsel, do voir dire, you have jurors who are appropriate to be here. And I will also allow you to do multiple peremptories. And if there's any challenges for cause, please approach. And I don't know, because it is rare to have 18 counts. I don't know if they'll need additional peremptories or if they'll have enough jurors for that. If we need to, we'll continue on Monday. If you believe that you need additional peremptories, please approach and we'll talk about that on a break. May we proceed in that fashion?
Absolutely, Your Honor.
Yes, Your Honor, agreed. Thank you.
All right, and is this a case where the jurors will be allowed to ask questions?
I prefer that in every case I do.
Okay,
And note taking, yes. Please.
yes, always note taking in my courtroom, and they'll be allowed to ask questions, so we'll make sure that's in the next set of instructions.
And after my last trial, I assume you guys are telling them to not come to court with questions, right?
You know, sadly, yes, as you know, I go way off the page. At some point, we should probably put together a letter for the Supreme Court to quickly amend these jury instructions. They are becoming very old.
I know every odd out of place instruction is because of an incident that's happened, and I just remember that from my last time in this courtroom.
We've had several before this court, so yes.
Thank you.
Anything further?
I don't believe so. Not on behalf of the people, Your Honor. I know the court has another matter it's handling this morning, but the people are ready for trial.
We could always do that on a break. Neither one will take very long. And I don't see defendants counsel, so we could do that on a break.
Yes, Your Honor. I have no other matters to bring to the court's attention between now and Monday morning.
I'm missing jurors 272 and 303.
Did they check in downstairs?
I'm guessing they checked it out, so they're on the final list. 272 and 303.
Okay, counsel, did you hear that? He is missing jurors 272 and 303. Perhaps they were in the restroom. I don't know.
I called the whole roll and then I called for them again afterwards at least 4 times and nobody spoke up.
And did you talk to the jury clerk?
No, I have not called down there.
Okay, why don't we bring them in and then you can go in the back and make a call, and I'll also call out to see if they are in the room.
Okay.
And I'll need everybody brought up as much forward as possible.
Yep.
We'll quickly release them.
We're ready then?
We are ready unless there's anything else, counsel.
Not on behalf of the people.
Anything else?
No, Your Honor. Thank you.
Thank you.
All right.
See if those people are here.
All right, thank you. You all may be seated. Those of you who don't have seats, we will get your seats very quick. Now, I need you to make sure that you have your full sequence number out, and we are missing potentially 2 jurors, 272 and 303. Are you in this room? Is anybody 272 or 303? Okay, seeing no hands, we will see if we can locate them in the building. All right, thank you. Good morning, ladies and gentlemen. I'm Judge Rosemary Aquilina, and it's my pleasure and privilege to welcome you to the 30th Circuit Court of Ingham County. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our system of self-government could not exist without it. The jury is an important part of this court, and the right to a jury trial is an ancient tradition and part of our heritage. The law says that both the person accused of a crime and the prosecution have the right to a trial, not by one person, but by a jury of 12 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide this case. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask you questions. This is called voir dire. The questions are meant to find out if you know anything at all about this case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, defendant, or any witness. One or more of these things could cause you to be excused in this particular case, even though you may be otherwise qualified to serve as a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires we obtain this information so an impartial jury can be chosen. If you do not hear or understand a question, please say so. If you do understand it, please answer it truthfully and completely. If there is something that you want to tell us but not in front of the entire jury, please let me know. And when we take a break, I will have you address the court with only necessary court personnel in the room. Please do not hesitate to speak freely about anything you believe we should know. Oftentimes, because I talk to every jury afterward, I bring counsel in, we talk, it's kind of a learning experience, and then we might be able to answer questions we couldn't do during the case in chief because of the rules we operate under. But oftentimes, jurors will say, I'm surprised you didn't ask me whatever question it was. And then counsel will say, well, I probably missed that, or I should have. So if there's something like that, don't wait to tell us till after the case. Please just raise the issue and tell us. So if there's something important, we are happy to listen to it. I need you to make sure that you do have that rule sequence number. I'm going to go out of order. I'm going to swear to you, and I'm going to go out of order because I want to make sure that you all have seats and that we have, during the voir dire process, which will take a good part of the day, I want to make sure that we have jurors who should be here. Some of you will not be able to serve for various reasons, and we'll talk about that. So in a moment, I will ask you to raise your right hand and swear to answer truthfully, fully, and honestly all the questions you will be asked about your qualifications to serve as juror in this case. If you have religious beliefs against taking an oath, you may instead affirm that you will answer all questions truthfully, fully, and honestly. Please raise your right hands. So I'm going to read the alleged charges against defendant, but first I'm going to introduce you to my staff. My law clerk, Brian Ring, you've already met him. He's the one that brought you up. He's a go-to person. If you need a break, if you need information, if something has arisen, please ask him to give you whatever information or bring it to my attention. The court reporter is my silent partner, Nancy Renke, and she takes down every word that is said in this courtroom. So we start with a blank piece of paper. By the end of every day, we have a transcript of what happened in this courtroom, which means that she's not allowed to guess, and she must take down words. So instead of nodding yes or no or saying or well, she can interpret, the M's for and the or whatever. It would be interpreting whether it means yes or no. So we need you to be very, very clear and say yes or no, rather than shaking your head, and answer with words that could be found in a dictionary. My judicial assistant, Nicole Smith, she's the one that once you are chosen, she's behind the scenes, but very much a part of what we do. And if you buzz back, you will see Nicole. She is also a go-to person. And we also have a deputy clerk with us. And she's the one that she's seated to my right, and she is the one who's keeping track of all of you, which is really, really important. And then you see also to my right a number of other people. Those are law students or undergraduate students. I teach at both Cooley and Michigan State College of Law, as well as undergraduate at Michigan State. And the students often do volunteer or do work for credit to learn about the judicial process, which is in the legal system, which is really important. So they are also here to assist the court and to watch everything that happens. Ryan, did you need me?
No, Judge.
Okay. Did you find out about the other two?
They are going to go look for them. They are not sure, but at least one of them, Jennifer specifically gave instructions to and knows that was here earlier.
All right. So it's really important that you're here and that we know the number. As you raise your hand, I will address you, but I first need to have the full sequence number. The clerk is going to keep track of that, as will the court reporter. Those people who decided this is like college and may have taken off once they checked in, or those people who simply didn't show up at all, what happens is there's a bench warrant that will be issued, and then they will be arrested, and they will be housed at our hotel in Mason. They may or may not be in our lovely jumpsuits. And then they will be brought before a judge, and they can be held in contempt, fined, and then they still have to do jury duty. So they can get away with anything. So thank yourself for looking in the mirror when you question, should I show up, for saying yes. It's really that important to our justice system. So on behalf of counsel and the court, we thank you for your service today, whether or not you were chosen. It's just such an important part, and it's absolutely imperative that you show up, and I appreciate the importance that you gave this matter. So this is a criminal case involving the charges of count 1, torture, count 2, assault by strangulation or suffocation, count 3, assault by strangulation or suffocation, count 4, assault with intent to do great bodily harm less than murder or by strangulation, count 5, assault with intent to do great bodily harm less than murder, count 6, domestic violence, count 7, home invasion first degree, count 8, interfering with a crime report, committing crime, threatening to kill or injure, count 9, assault with a dangerous weapon, count 10, felony firearm, count 11, interfering with electronic communications, count 12, aggravated stalking, count 13, criminal sexual conduct first degree, multiple variables, count 14, computers, using a computer to commit a crime, count 15, personal identifying information, obtained, possessed, transfer with intent to commit identity theft, count 16, intentional dissemination of sexually explicit visual material, count 17, weapons, firearms, receiving and concealing, and finally, count 18, felony firearm. I will explain each of these more fully later. Now, the defendant has pled not guilty to each of these. And my questions to you now, please raise your hand. I will go from this side of the room to the other side of the room and call on you. I need you to give me your full sequence number. The first question I have is, because I've read 18 allegations, understanding that he has a right to a jury trial and he's pled not guilty, and the people have the burden of proving each count beyond a reasonable doubt. Is there anyone who has already made up their mind that because there's 18 allegations, he must have done something, so that you have already, because you have to be fair and impartial to both sides. If anybody can't do that after hearing these counts, or if it's triggering to you because you or a loved one have been subjected to domestic violence or sexual assault or any of these other counts, please let me know. We need you to pay attention. If you're triggered by something, then that's a problem. So, or if you've already made up your mind without hearing any evidence, that's a problem. And we'll get to other issues. If you have religious beliefs against making a decision against a fellow citizen, you leave that totally up to God, not the courts. Let me know, okay? On this side of the room, please raise your hand.
And if you're sitting down, stand up.
Stand, please. All right, ma'am or sir, let's start with you. What is your number?
It's 335.
And what is the issue?
The amount of counts.
So you've already, instead of a level playing field, you've already said it's against defendant?
Absolutely.
And counsel, what we'll do is, I will, if you object, please let me know, otherwise I will release them just to save time. Any objections proceeding in that fashion?
No, I think that's best.
No, Your Honor, thank you.
Sir, you're excused. Ma'am, what's your number?
326.
And what is the issue? Triggered? Have you, so you can't, based on what's happening in your life, you can't be fair and impartial? Is that correct?
Yes.
You're excused, ma'am. I already see that you're upset. Thank you. Anyone else on this side, please raise your hand. All right, sir, well, ma'am in the corner, in the gray, what is your number?
It's 325.
What's the issue?
Assault trigger.
You're excused. And sir, in the blue, what is your number? What is your issue?
390, triggered by a family member that was a victim of sexual assault.
You're excused. And seats empty, please fill them up.
Excuse me.
Ma'am in the green, what is your number?
456.
What is the issue?
Too many counts triggered.
You're excused. In back of her in the red, yeah. What is your issue? What's your SU? What's your number?
227.
I'm sorry, 237?
227.
227. And what is the issue?
The number of counts.
So you can't be fair and impartial?
Plus I'm a retired correctional officer.
Oh, you're excused, sir. Thank you for your service. Okay. Ma'am, in the purple, I'm trying to go front to back. So in the purple, what is your number?
189.
And what is the issue?
Children have been stalked before and victim of.
I hear the sadness in your voice. You're excused, ma'am. And sir, in the black shirt, what is your number?
374.
And what is the issue?
I had a daughter that was sexually assaulted.
You're excused, I'm sorry. All right, you're excused. Sir, in the brown shirt here on the end, you, what is the number?
257.
And what is the issue?
My sister was sexually assaulted.
So you can't be fair and impartial?
No, because the other victim, they was sexually assaulted with her.
You're excused, sir, thank you. All right, in the gray up front here, ma'am, what is your number?
174.
And what is the issue?
The number of accounts, and I have friends with domestically, a victim of domestic violence.
So you can't be fair and impartial?
No.
You're
And I
excused.
fathered kids who were sexually assaulted.
Oh, sorry, you're excused. Okay, as seats become empty, please take them. All right, and that will help you see too. Sir, in the purple, what is your number?
350.
And what's the issue?
My sister was sexually assaulted.
I'm sorry, you are excused, sir. And in the plaid shirt, what is your number?
249.
And what is the issue?
My husband was sexually abused.
And you'll bring that into this case? You're excused. Ma'am there in the gray, yeah,
164, I was in an abusive marriage.
and you'll bring that into this case? You can't be fair and impartial? So you can't be fair and impartial, yes? You're gonna bring that into the case? I just want to be clear.
I can't do the case.
Okay, you're excused. And sir in the gray, what is your number? You, with the glasses on? Yeah, sorry. Sorry to point at all of you, I just don't know how to do this otherwise. Sir, right there, right, you. Yeah.
218.
2,
218.
thank you. What is the issue?
Too many counts.
So you can't be fair and impartial? You're excused. All right, ma'am, I don't know if that's navy or black. Yep.
426, just victim of domestic violence.
And you'll bring that into this case, you can't be fair and impartial? So yes?
Yes.
Okay, you're excused. Ma'am, there was your hand raised.
271.
What's the
My
issue?
mom was a victim of domestic violence.
I didn't hear the beginning.
Could you repeat that, please?
My mom was a victim of domestic violence.
And so you cannot be fair and impartial? And you just need to speak up.
I cannot.
Thank you, you're excused. There are seats empty, please take them if you're standing. All right, sir in the white, what is your number?
393.
What is your issue?
Due to the number of counts I've already made up in mind.
And that would prejudice one side or the other? You're excused. Ma'am in the white striped shirt, I think it is. What is your number?
417, I have a family member who was sexually assaulted.
And you can't be fair and impartial? You're excused. Sir in the brown shirt, what is your number?
327.
And what is the issue?
Sister was a victim of domestic violence.
And you can't be fair and impartial? You're excused, and that was a no, sir?
No.
Thank you, you're excused. Ma'am in the black, what is your number?
299,
And what is the issue?
my sister was also sexually abused.
And you'll bring that into this case? Is that a yes?
Yes.
You're excused, ma'am. Again, just a reminder, speak up and use words. And there's empty seats, please either move down in the row, because I would like to get everybody seated, it'll just be easier for me to see, and all of you should have a seat. All right, sir, in the blue aisle, in the blue shirt in the aisle there, what is your number?
231.
And what is the issue?
The number of counts.
You've already made up your mind?
Yes.
You're excused, sir. In the front, the white and black,
My sister-in-law was a victim of domestic violence.
what is your number?
Oh, sorry, 421.
And you'll bring that into this case?
Yes.
You're excused.
Yeah.
Sir, in the blue, what is your number?
288, there's just too many counts.
You've already made up your mind?
Yes, ma'am.
You cannot be fair and impartial?
Correct.
You're excused. Sir, in the black, what is your number?
My number is 412. My mother was a victim of sexual assault.
And you'll bring that into this case?
Yes.
Can't be fair and impartial?
No.
You're excused. Sir, in the blue shirt, what is your number?
422.
And what is the issue?
Too many counts.
You made up your mind?
Yes.
Can't be fair and impartial? You may have a seat, or you may be excused. And in the back there, the light brown shirt, what is your number? You, yes.
178.
And what's the issue?
My sister was a victim of sexual assault.
You'll bring that in this case? You're excused. Sir, next to her, what is your number?
433,
And what is the issue?
my college roommate was falsely accused of raping a woman.
So you'll bring that into this case?
Absolutely.
You are excused. And you're, yes. What is your number?
454,
And what is the issue?
too many counts, home invasion, and I was corrections. Worked in corrections.
You're excused, thank you. Ma'am in the light blue, you, yes?
354,
What is the issue?
too many counts.
You've made up your mind?
Yes.
Can't be fair and impartial? You're excused. Ma'am in the back there in the black, what is your number?
223.
And what is the issue?
The charges are just,
Have you made up your mind?
yes.
You can't be fair and impartial? You're excused. Sir in the black, what is your number?
169.
I just figured there's too many charges, I don't feel like I can really be fair.
You're excused. In the purple there, what is your number?
458,
And what is the issue?
I've experienced sexual violence.
I'm sorry. And so you'll bring it into this case and be triggering? Is that a yes? You're excused. Sir, or ma'am, in the brown? I can't, okay, yeah. I'm sorry?
212.
And what is the issue?
My mother's a victim of domestic abuse and sexual assault.
And you'll bring that into this case, you can't be fair and impartial, are both of those things true?
Yes.
You're excused. Sir, in the black, what is the number?
321.
And what is the issue?
Too many charges.
You've made up your mind? Is that a yes?
Yes.
Can't be fair and impartial?
Correct.
You're excused, sir. In the brown sweater,
Family victim, too many counts.
you've made up your mind to bring that, and you'll bring that other case into this case? You're excused.
number.
And could you tell me the number again?
334.
234?
334.
334, glad I asked, okay. And there in the gray sweater, what is the issue?
240 CSC.
And you'll bring that into this case? Terribly sorry, you are excused. All right, and there's, okay, ma'am, in the blue, what is your number?
172.
172?
Yes.
And what is the issue?
Family members have been assaulted and sex assaulted.
I'm terribly sorry, you'll bring those into this case? You're excused. Sir, in the blue shirt, what is your number?
344,
And what is the issue?
number of charges.
So you've made up your mind?
Yes,
Can't be fair and impartial?
that is.
You're excused. If you have a seat by you, please raise your hand. Is there empty seats? Oh, do you both have issues? All right, ma'am, in the red, what is your issue?
198, too many counts. Something I was assaulted.
And you can't be fair and impartial? You are excused. Ma'am, in the blue, what is your issue?
My number is 429. I had an adult that was sexually assaulted.
And so it'd be difficult for you to be here? Does he ask?
Yes, it is.
You're excused, ma'am. I told you you'd all get seats quickly. Okay. Anybody else on this side of the room? Okay, let's turn to this side of the room. If you could all stand, and anybody who wants to tell me something. Sir, in the green, what's your number?
My number is 371. Had former students sexually assaulted, triggering.
You're excused. Ma'am in the black, what's your number?
Too many counts on domestic abuse.
What's your number?
348.
348, and so you can't be fair and impartial? You're excused. In the gray, what's your number?
411.
And what's the issue?
Triggering, I was in a domestic violence, choked out,
You're-
and a choice of who died.
You're excused, ma'am. I'm terribly sorry. Ma'am in the blue, what's your number?
203.
And what's the issue?
I'm a survivor of sexual assault and domestic violence. I don't think I would be a fair juror in this case.
And I hear that you're upset. I'm sorry that happened, and you are excused, ma'am. In the blue, what's your number, ma'am?
220.
And what is the issue?
I'm already had a trigger. I wrote them.
You're excused, ma'am. Sir, in the blue, what is your issue? What's the number?
438.
I'm sorry,
438.
thank you.
Too many charges for me to see them as, I'm not going to.
You're excused. Sir, in the gray, what is your issue? And your number?
202, too many counts. I can't feel like impartial with that.
You're excused. In the black and white, ma'am, what is your number?
431. I came in here feeling like I could completely be fair and impartial. And when you after counts 1, 2, 3, 4, 5, my stomach started. I just don't believe I can be impartial.
I already hear
There's to
the,
say.
yeah, I hear the anxiety. It's not a problem. So I go through this. I go through it early before we get into more details for all of you. So we need a jury that can be fair and impartial. Appreciate everybody's honesty. You're excused, ma'am. In the green, yes. What is your number?
395.
And what is the issue?
Too many charges.
You can't be fair? Is that a no?
No.
You're excused. Ma'am, what is your number?
189, which was already called, but 189.
189 was already called? Let me just figure this out, because I wonder if that's one of the numbers that I'm missing.
I have 198.
Yeah, I have 189 scratched off already.
So let's scratch off. Is anybody else at 198?
189.
189?
Yep.
How about 198?
198 was already dismissed as well.
So that's somebody reversed it. She was probably 188.
No,
I've had
both were called, so
both were
someone
called and dismissed.
already gave her number.
That's what I'm saying. They probably, both were called?
Yes, both were.
Well, just highlight it, because I don't want to benchmark someone without.
I'll look at the, I'll look at the ideas, see if I can match them with the 189 at the end.
Okay, we're gonna figure it out. Somebody's gonna be called in. All right, so I'm sorry, what was your issue?
I was sexually assaulted in college.
And you'll bring it into this case? Terribly sorry, you're excused. Yes, and what is your number?
My number is 261.
And what is the issue?
I've been in an abusive relationship before that involves abuse counts, so I don't feel like sharing.
You can't be fair and impartial. You're excused. Ma'am, and there in the gray, what's your number?
336.
And what is the issue?
Too many counts and triggering for me.
You're excused.
Thank you.
Sir, yeah, you, what is the number?
423. Yes, 423. Too many counts, and I feel like I can't be impartial in this.
You're excused. Ma'am, in the, I think it's gray or light blue?
Here,
Yes.
295.
What is the issue?
When we got up to like the 10th count, I don't think I can remain impartial.
You've already made up your mind without hearing any evidence?
Yes.
You're excused, ma'am. Sir, in the 10,
352,
sorry, 252?
352,
352, and what is the issue?
too many counts, Your Honor.
You've already made up your mind? You can't be fair and impartial? You're excused. Leaning against the wall in the 10, what is your number?
310.
And what is the issue?
Oh, I'm sorry, I didn't have an issue.
Oh, and you need a seat.
Everyone was asked to stay on it.
Oh, no, just, I'm sorry, just the, those with an issue.
Okay.
Okay, I'm glad to have somebody sit down. Okay. Ma'am, in the corner there, what is your number?
187.
And what is the issue?
Too many charges.
You can't be fair and impartial? Well, you don't think so. You listen to the outcome, you can't be. You've already made up your mind. Is that a yes?
Yes.
You're excused. Sir, in the yellow shirt, what is your number?
244, sexual assault of a family member.
And you can't be fair and impartial?
No, Your Honor.
You are excused. And sir, finally, what is your number?
265,
And what is the issue?
too many counts.
Can't be fair and impartial?
No,
You've already made up your mind?
yes, ma'am.
All right, you're excused as well.
Thank you.
Can't do that with that discrepancy.
Does anybody have religious beliefs against making a decision that where you feel that as judges we shouldn't be doing this, as jurors we shouldn't be doing this, it's totally left in God's hand? Okay, and so let me go back to reading. Making sure that we cover everything, since we've cleared the room and you all have seats. During jury selection, you may be excused from serving in the jury in one of two ways. First, I may excuse you for cause, and you've just seen that. We excuse about a third of the room. That is, I may decide there's a valid reason why you cannot or should not serve in this particular case. Or a lawyer from one side or the other may excuse you without giving any reason at all for doing so. This is called a peremptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel badly or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. The restrictions I'm about to describe are meant to ensure that the parties on each side get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you consider must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these standards, it could give you incorrect or misleading information that might unfairly favor one side or the other. These restrictions continue until I discharge you from jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. This would include not making new friends on Facebook, TikTok, Instagram, X, or any other platform. We've had people do that in the past, and they connect with witnesses or even the defendant. Please do not do that. We've also had people go out in the hall as I read the felony information and you know more about this case. We've had people go out in the hall and Google the attorneys, defendant, any other names they hear. You cannot do that either. You must also not research any aspect of the case during the trial. This means research using a cellular phone, computer, AI, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. It means that you cannot go in the hall and use Chat GPT to inquire about the charges or anything else. So no communication about this case at all. Everything you need will be given to you if you're chosen to be seated during the trial. But right now, we also have this because we need you to not gain any information that you don't have right now. You must not investigate the case on your own or conduct any experiments concerning the case involved, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial if it would be become necessary for you to view or visit the scene, court staff will take you there as proof under court supervision. You must not consider as evidence any personal knowledge you may have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media, websites, or in any other manner, or discuss it with anyone else, including other juror members or potential juror members. If you discover that a juror or potential juror has violated these instructions, please report it to this court and the law clerk at once. These charges that I read, the 18 counts, will be explained more fully in a few moments. But meanwhile, these charges have been made against defendant, who is Enrico Brooks. Defendant's lawyer is Stephen Freeman. Counsel, please introduce yourself and your client, and anyone else seated at counsel table. Sir, please also stand.
Yes, Your Honor. Thank you very much. Good morning, everyone. My name is Stephen Freeman. I'm a public defender here in Amy County, representing Mr. Antonio Brooks. He's a gentleman in the plum-colored shirt. And this young lady is one of the paralegals from our office, Kayla Douglas, and she's here to assist for the jury selection process. After this morning, she gets to go back to the office. Thank you, Your Honor.
Thank you. The lawyer for the state of Michigan is Assistant Prosecuting Attorney Adam Pfeiffer. Mr. Pfeiffer, please introduce yourself and anyone else seated at counsel table, and then any potential witnesses you may call in this case.
Absolutely. Good morning, everyone. As you heard, my name is Adam Pfeiffer. I'm the Assistant Prosecuting Attorney handling this case. Seated with me will be throughout the trial is Detective Tara Brandon from the Lansing Police Department. As far as potential witnesses that we expect to call, those include Detective Tara Brandon, Detective Martha McGonigal, Trooper Zachary Darter, and Alyssa Clark.
Thank you. Mr. Freeman, are there any additional potential witnesses you may call?
Thank you very much, Your Honor. Not at this time, though.
Thank you very much. Now, does anyone know defendant, any of the potential witnesses, or any of the lawyers? If so, please raise your hand. On this side of the room, seeing no hands raised. On this side of the room, seeing no hands raised. We think that this trial will last approximately 4 days. Of course, we have no way of telling, and the attorneys, I don't even get police reports, okay? So I don't know, I rely on the attorneys, and they're usually pretty good, they know their cases. So they have estimated about 4 days, which will be Monday. So today, as soon as we pick you, we will release you until Monday. Monday, we will go from 9 until 3. We will have a shorter lunch so that we can move things along. So lunch on Monday will be courtesy of the county. We usually only provide lunch during deliberation. However, because I'm shortening it up, because I have another matter to handle between 3 and 5, we will be paying for lunch on Monday. Technically, you're all paying for it through tax dollars, so thank you for lunch. And then Tuesday will be 9 to 5. Wednesday, I have to handle other matters to keep my docket moving on behalf of the county. So I hear pleas and motions and civil cases, and I have a juvenile weapons court. There's a lot of things that happen on Wednesday. So unless it's absolutely necessary, we don't generally cancel a Wednesday. So you will not be here Wednesday. Thursday, 9 to 5. Friday will be 9 until about 11:30 or so. I have a commitment to perform a wedding that is out of county, so I'll be doing that Friday afternoon. And then if you have not, we anticipate that you'll be in deliberations likely Thursday, but again, I never know how a case is going to go. So deliberations would continue into Friday. You'd be released at 11:30 if you have not made a decision by then. We'll continue Monday 9 to 5, Tuesday 9 to 5, and so forth, including Wednesday 9 to 5 if you needed that time for deliberation. I have had jurors deliberate for half an hour. I also have had jurors deliberate for 5 days. There is absolutely no limitation on the length of time for deliberation. It takes the time it takes, and you have that ability to talk amongst yourselves in the jury room for as long as needed. And of course, you've heard how many counts there are, so it may very well take you more than one afternoon or more than 1 or 2 days. I simply don't know. And like I said, I have no idea what any witness will say or what's happened here, because someone could want a bench trial. So I know a little bit more than you, but not much. So I'm worried about this case like you. So I'm just giving you my best estimate about the time frame and the information. Now, if you believe the length of this trial will be a real hardship, please let me know. Now, before you raise your hand, I'm looking for hardship. We all appreciate this is an inconvenience, and I want you to know I've had federal judges who've been called in front of me. I've been called regularly 3 times for my own case. I've had to reschedule. Okay, I've been a judge a long time, so 3 times for my own case. So no one's really exempt from that. You might think I don't have to serve, but I too have to do this duty, and you can be exempted for certain reasons. But we're looking for a hardship, not an inconvenience. So we appreciate your service. There are a lot of reasons though that this may interfere with your life and cause a hardship. If it is a hardship, please let me know. On this side of the room, please stand and let's address whatever hardship you think it is. All right, ma'am, what is your number in the blue first row?
450. I am technically high-risk pregnant, and I do have appointments next Thursday.
So high risk meaning it would be probably tough for you. I have 5 kids, so I get it.
This is not more.
Yeah, so would it be difficult for you to sit in these jury chairs for 8 hours? Okay.
I just have like appointments for follow-ups and stuff next week.
Okay, so when are the appointments? Thursday?
Yeah.
And that's not something you can miss or change.
I could try, but it took a couple weeks for them to get me on the schedule for it.
Yeah. Okay, any objection, counsel?
Absolutely not.
No, Your Honor.
All right, you are excused, ma'am. Good luck.
Thank you.
And sir in the black, what's your number? And by the way, ma'am, if you are nursing next year, you are exempt. If you get called, you just call in because nursing mothers are exempt.
I wish I would have known that last year when I was.
Thank you. Most people don't know, so that's why I'm telling you. Good luck. Thank you. Sir, what is your number?
376. I have a job interview on Monday. That was scheduled.
When is the interview?
10:30.
I'm sorry,
10:30.
counsel?
I have no problem excusing until you make that.
No objection.
You're released, sir. Good luck. Sir, what is your number?
331.
And what is the issue?
Self-employed.
So financial hardship?
Yes, it is.
You're excused, sir.
Thank you.
Ma'am, what is your number?
396.
What is the issue?
International travel planned after June 12th. So June 12th is my last day in the Lansing area.
Okay. We're not gonna be here till June 12th, are we, counsel?
I would be very surprised if we were.
Well, I would be shocked. So, ma'am, you can do your travel. All right, sir?
452. I started the job Friday and then I fly to Colorado for onboarding Sunday.
You're excused, sir. Ma'am? What's your number?
175.
What's the issue?
The issue is that I am primary caregiver for my mother tonight, and she's in hospice.
She's in what?
Hospice.
Oh, so would you be worried about her? Hospice means she, yeah. I don't have any problem with that, counsel.
Oh, no.
Yeah, you're excused. I'm sorry to hear that, ma'am. And ma'am, what is your number?
291. I have a work conference next week. I will be leaving Wednesday afternoon, and I will go on Wednesday, Thursday, and Friday to New York. I'm unable to,
That's okay. I'd like to be in New York too. You're excused, ma'am. Ma'am, what is your number?
446.
And what is the issue?
I have work travel starting the 9th, so as long as it ends
I would be totally fine, but if it goes into that, I'm leaving at 6:30 on the 9th for the rest of the week.
You have a seat. I doubt it's gonna go, and we do have alternates.
Okay.
So we have 2 alternates, so that's not a problem. Sir, what is your number?
338.
And what is the issue?
I'm my wife's primary care provider, and she has terminal brain cancer. We have 3 appointments next week.
You're excused, sir. I'm sorry to hear that. On this side of the room,
310.
what is the issue?
I'm traveling to Chicago on Wednesday for a trade show where I'm presenting. And I would have a really hard time getting out of it.
That's okay. That's Wednesday. Are you taking the train in the morning, coming back in the evening, or?
I'm driving and I won't be there until Friday.
You're excused. Sir, in the blue, what's your number?
165. I was off work for 2 months for a knee replacement. I just started back.
So is this financial hardship? Let me just say that nobody can be fired for being here. I did have a doctor's office who fired someone who worked there for jury duty. They brought a suit, guess who won? And the doctor learned a big lesson, so no one can be fired, but, so sir, if firing is the issue, that's not.
Firing, it's a money issue at this.
All right, financial hardship?
Yes.
That, you're excused, sir.
Sir, was that 165?
Yes.
Okay, thank you.
Thank you. Sir, on this side of the room, what's your number?
278. My wife's got a medical appointment on the 9th, and I need to drive her to colonoscopy, so I can be her driver, but if we're wrapped up by the 9th, then I'm.
Have a seat. Thank you for letting us know. Sir, in the green, what's your number?
262.
And what's the issue?
I have a second part of a week-long training that won't, for work, that won't be rescheduled until the following fall.
You're excused. Ma'am, what is your number?
345. I work in Boston, and I scheduled next week. I canceled today to be here, so I don't know.
So you'll be in Boston?
Yes.
You're excused. Now, some of you may have health problems that might prevent you from serving on a jury. If you need to take your insulin, have breaks because of food, other issues like that, we're used to accommodating people for it, those kinds of things. However, there are people, I've had someone in here on a morphine drip, not a good idea. If you take medicine that keeps you up all night, so during this day you're drowsy, if there's something that, medicine that you take because of pain that makes you drowsy, if there's some reason you can't pay attention, let me know. We take breaks about every 1.5 to 2 hours because we all need to stand up and stretch and have coffee, water, whatever it is. So if you can't sit for 2 hours because of back problems or knee problems or whatever it is, let me know. If you are working third shift and you think you can work third shift and come to court, no, you will not be working third shift. You'll be sleeping and then coming to court. However, I've had people who work third shift who simply, because their body clock will not let them sleep, even if they try to stay home at night and sleep and then do something the next day. That's a problem. We need to know that. So anything else you have in regard to health issues, let me know. If you can't hear around the courtroom what's been said so far, we do have headphones that might help. We need you to be able to see and hear everything. If you're having problems doing that, let me know. If you can't pay attention, maybe you are unmedicated ADHD or have some other kind of issue, you can't pay attention, let me know. There's a lot of things. If you don't want the group to know and you want to talk to me privately, let me know that too. On this side of the room, anything you want me to know? All right, good. On this side of the room, anything you want me to know? Okay. Good. See no hands raised. As I've said, this is a criminal case. The paper used to charge the defendant with a crime is called an information. The information in this case charges defendant Enrico Brooks and reads as follows. People of the state of Michigan versus Enrico Brooks. that on or about November 16, 2018, in the city of Lansing, county of Ingham, state of Michigan, defendant did in count 1, torture, on or about May 25th, 2020, at 1701 Millstone in the city of Lansing, county of Ingham, state of Michigan. Did with the intent to cause cruel or extreme physical or mental pain and suffering, inflict great bodily injury or severe mental pain or suffering upon Alyssa Clark, a person within his or her custody or physical control. This is contrary to laws of the state of Michigan. Count 2, assault with intent to do great bodily harm, less than murder or by strangulation, that on or about May 25th, 2020, at 1701 Millstone in Lansing, Michigan, county of Ingham, state of Michigan, defendant did make an assault upon Alyssa Clark by strangulation or suffocation, contrary to the laws of the state of Michigan. Count 3, assault with intent to do great bodily harm, less than murder or by strangulation, that on or about January 1st, 2020, through and including December 31st, 2020, at 1701 Millstone in Lansing, Michigan, county of Ingham, state of Michigan, defendant did make an assault upon Alyssa Clark by strangulation or suffocation, contrary to the laws of the state of Michigan. Count 4, assault with intent to do great bodily harm, less than murder or by strangulation, that on or about June 1st, 2020, through and including June 30th, 2020, at 1701 Millstone, Lansing, Michigan, Ingham County, state of Michigan, defendant did make an assault upon Alyssa Clark by strangulation or suffocation, or with intent to do great bodily harm, less than the crime of murder. This is contrary to the laws of the state of Michigan. Count 5, assault with intent to do great bodily harm, less than murder or by strangulation, that on or about May of 2020 at 1701 Millstone in Lansing, Michigan, county of Ingham, defendant did make an assault upon Alyssa Clark with intent to do great bodily harm, less than the crime of murder, and this is contrary to the laws of the state of Michigan. Count 6, domestic violence, on or about May 25th, 2020, at a specific location known as 1701 Millstone, Lansing, Michigan, county of Ingham, state of Michigan, defendant did make an assault or assault and battery upon Alyssa Clark, a resident or former resident of his household, and or an individual with whom he had a child in common, and or an individual with whom he had a dating relationship. This is contrary to the laws of the state of Michigan. Count 7, home invasion, first degree, that on or about May 25th, 2020, at 1701 Millstone, Lansing, Michigan, county of Ingham, state of Michigan, defendant did break and enter or did enter without permission a dwelling located at 2700 Eaton Rapids Road, Lansing, Michigan, county of Ingham, and while entering, present in, or exiting, did commit an assault, and while entering, present in, or exiting the dwelling, Alyssa was lawfully present therein. This is contrary to the laws of the state of Michigan. Count 8, interfering with crime report, committing crime, threatening to kill or injure, that on or about May 25th, 2020, at 1701 Millstone, Lansing, Michigan, county of Ingham, state of Michigan, defendant did, through the unlawful use of physical force, prevent or attempt to prevent another person from reporting a crime committed or attempted by another person, and the violation involved committing or attempting to commit interfering with electronic communications against a person. This is contrary to laws of the state of Michigan. Count 9, assault with a dangerous weapon, also known as felonious assault, that on or about May 25th, 2020, at a specific location known as 1701 Millstone in the city of Lansing, county of Ingham, state of Michigan, defendant did make an assault upon a illicit dangerous weapon, to wit, a firearm, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to the laws of the state of Michigan. Count 10, weapons, felony firearm, on or about May 25th, 2020, county of Ingham, state of Michigan, defendant did carry or have in his possession of firearm, to wit, a handgun, at the time he committed or attempted to commit assault with a dangerous weapon contrary to the laws of the state of Michigan. Count 11, interfering with electronic communications on or about May 25th, 2020 at County of Ingham, State of Michigan. Defendant did willfully and maliciously prevent, obstruct, or delay by any means the sending, conveyance, or delivery of an authorized communication by or through a telephone or telephone line. This is contrary to laws of the state of Michigan. Count 12, aggravated stalking. On or about November 16th, 2018 through and including January 1st, 2024. In the city of Lansing, County of Ingham, State of Michigan, defendant did engage in a willful course of conduct involving repeated or continuous harassment of Alyssa. The conduct being such that would cause a reasonable person to feel frightened, intimidated, terrorized, and threatened. Said conduct actually causing Alyssa to feel frightened, intimidated, terrorized, and threatened. At least one of the actions constituting the offense is in violation of pretrial release, and the course of conduct included the making of one or more credible threats against Alyssa, contrary to the laws of the state of Michigan. Count 13, criminal sex conduct, first degree, multiple variables. On or about January 1st, 2020 through and including December 31st, 2020 at the County of Ingham, defendant did engage in sexual, to wit, object into anal under the following circumstances. Defendant had reason to know the victim was physically helpless or mentally incapacitated or mentally incapable, and the victim sustained personal injury. This is contrary to the laws of the state of Michigan. Count 14, computer using to commit a crime. On or about September 1st, 2023, through and including September 30th, 2023, in the city of Lansing, County of Ingham, State of Michigan, defendant did use a computer program, computer system, or computer network to commit, attempt to commit, conspire to commit, or solicit another to commit pursuant to the statute. Personal identifying information obtained, possessed, transfer with intent to commit identity theft, contrary to the laws of the state of Michigan. Count 15, personal identifying information obtained, possessed, transfer with intent to commit identity theft. On or about September 1st, 2023, through and including September 30th, 2023, at Lansing, Michigan, County of Ingham, defendant did sell or transfer or attempt to sell or transfer personal identifying information of Alyssa Clark, knowing or having reason to know that the recipient would use, attempt to use, or transfer the information to another person for the purpose of committing identity theft, contrary to the laws of the state of Michigan. Count 16, intentional dissemination of sexually explicit visual material on or about September 1st, 2023, through and including September 30th, 2023. In the city of Lansing, County of Ingham, State of Michigan, defendant did with the intent to threaten, coerce, or intimidate, disseminate any sexually explicit visual material of Alyssa Charmaine Clark, another person who was not less than 18 years of age and was identifiable from the sexually explicit visual material itself or information displayed in connection with the sexually explicit visual material, and the sexually explicit visual material was obtained under circumstances in which a reasonable person would know or understand that the sexually visual material was to remain private and knew or reasonably should have known that the other person did not consent to the dissemination of the sexually explicit visual material. This is contrary to the laws of the state of Michigan. Count 17, weapons, firearms, receiving and concealing. On or about November 19th, 2024 at 3872 Wilson in the city of Lansing, County of Ingham, State of Michigan. Defendant did conceal a stolen firearm, knowing that the firearm was stolen, contrary to laws of the state of Michigan. Count 18, weapons, felony firearm, on or about November 19th, 2024 at 3872 Wilson in the city of Lansing, County of Hingham, state of Michigan. Defendant did carry or have in his possession a firearm, to wit, a handgun, at the time he committed or attempted to commit firearms, receiving and concealing, contrary to the laws of the state of Michigan. Defendant has pled not guilty to each of these charges. You should clearly understand that the information I just read is not evidence, and information is read in every criminal trial so that defendant and jury can hear the charges. You must not think it is evidence of his guilt or that he must be guilty because he has been charged, nor should you think that he is guilty because there are a number of offenses that he's been charged with. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that defendant is innocent. This presumption continues throughout the trial and entitles defendant to a verdict of not guilty unless you're satisfied beyond a reasonable doubt that he is guilty. Each crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. Defendant is not required to prove his innocence or to do anything at all. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Before I turn it over to the attorneys, now that I've read to you the full information, is there anyone who believes they cannot be fair and impartial throughout the whole trial? Please stand. What is your number, sir?
268.
And what is the issue?
I got teenage daughters, and it's, when you read those out, I was getting a little emotional. I don't think I did impartial or impartial this time.
You're excused, sir. Anyone else on this side of the room? How about on this side of the room? Thank you. On behalf of the people, you may proceed. And before as he comes up here, let me just
See.
just a moment. On behalf of the people, before I have a question, we're gonna call up 14 people, but I need you to all listen to the questions and think about how would I answer those, because I have two very competent attorneys who I know have hundreds of questions. And to avoid us all hearing those hundreds of questions multiple times, if you listen, there may be some questions they want to repeat. However, they simply can also say, you've heard the questions, is there anything you want to tell me? And that way, if you think about the questions, how you would answer them, you can give them some information so that they can follow up, and we'll just move through a lot quicker. So it's not time to think about lunch hour or anything else. It's really time to pay attention. We will run through the lunch hour. If you need a break, let me know. We will take some breaks in between all of this. But if we take a lunch hour, it's more like an hour and a half because there's so many of you, it could be 2 hours. So I tend to run through lunch and then release you early. I hope to be done by 2 or 3. If that's too long for any of you, you want to run down and get a hamburger or something, or take a brief break to the restroom, certainly we'll do all of that. Is there anyone who needs a restroom break right now? Okay, let's call the 14 up. Please pay attention. The pool sequence number will be called, and once you are in the jury box, you are no longer the pool sequence number. You are jurors 1 through 14. Counsel? I'm sorry, answer the clerk.
Pool sequence number 446. Number 7.
Thank you.
Morning. Still morning. As I said before, my name is Adam Pfeiffer. I have the privilege representing the state of Michigan in this matter. I am the domestic violence prosecutor for Ingham County. And as you guys are pretty well aware, this part is what we call jury selection, and it's a rather important part of the process because it's the only time that you and I get to interact with each other at any point in this trial. If you're chosen to serve on this jury, there will be no other talking between us. There's not even highs, hellos, no holding the door open. We, as the attorneys, have to fight every bit of Midwestern politeness that was burned into us growing up, and we have to basically ignore that you exist if you're serving as a juror on these cases. But this is the time when we can actually talk, and the purpose of it is pretty straightforward. Our goal is to ensure that we pick 14 jurors who can adequately serve on this jury, who are a good fit for this jury, and able to uphold both the rights of the defendant and the people in this trial. So if I or the defense attorney dismiss you, don't think of it as anything personal about yourself. In fact, it's not even that you're not cut to be a juror. You might be a really great juror on a different trial, on a different type of case. Now, I promise you, I'm not a particularly nosy person, but there are some things that are uncomfortable that I do have to ask about, especially in a case like this with these types of charges. So all I ask is you be as honest as you can. I promise there are no right or wrong answers to the questions I or Mr. Freeman ask you. All you have to do is be honest. That's it. Now, I know we went over this at least a little bit already and it cleared out about half the courtroom, but this is a case involving domestic violence, sexual assault, and, as you heard, torture. I don't expect anyone to be overly comfortable serving on a jury for that type of case. I don't expect anyone to be very comfortable hearing Alyssa tell you about what was done to her. But what I need to know is, does anyone here think that hearing that type of evidence, hearing injury photos, would make you so uncomfortable that you would be unable to pay attention to the testimony that's happening? Does anyone here think that the graphic nature of this type of case would make you so uncomfortable that you would have difficulty paying attention to the case as it goes on? By a show of hands, does anybody feel that that's going to be an issue for them? No one? Okay. Now, to any of the 14 of you sitting here, have any of you yourselves, a close friend or family member to your knowledge, been the victim of domestic violence or sexual assault, any type of abuse in that realm? Okay. We'll take you guys in order. Juror number 7. Who do you know that has been the victim of that type of abuse?
My teenage daughter.
And
No, well, not of sexual assault, but not to the extent of what's been read in the court today.
but domestic abuse, good term for it then, or just abusive relationship?
More abusive, toxic relationship.
And again, these are one of those things that I have to ask about, but is this something that's in the past or that's still currently going on?
That's
How far back are we talking?
about 2 or 3 years.
Okay. Hearing about what could be similar aspects here, would you be able to keep separate what your daughter went through when you're hearing those type of facts here, or would it be too difficult for you to do that?
That would be fine. I mean, in all honesty, my daughter hasn't even been able to explain everything to me and has had her own treatment that I haven't heard, so I feel like I could be fair in the court throughout this trial.
Were there charges?
No.
I understand what you mean, and I appreciate you being forthright about that. Juror number 14, who do you know who's been through that type of
A very close friend was repeatedly sexually abused as a child. She is the same age as I am. But it did happen. It was important.
Now, I will say this case does not involve sexual abuse of a child, for what that's worth. But hearing about a sexual assault, would it make you just too uncomfortable to be able to sit through this? Are you gonna be able to keep separate about what happened to your friend when she was younger versus what happened to Alyssa?
Yes.
Okay. And that's all we ask of you guys. We are not expecting anybody to serve on a jury as a blank slate. We can't. You guys are humans who have been shaped by your experiences, by the people you know in your life, what you've been through, what you've seen. We're not asking anyone to turn all of that on. What we ask, though, is that you keep the facts of them separate. You use your common sense and judgment that you gained from those experiences, but you don't apply the facts of what you've gone through or what you know someone else has gone through to what Alyssa's gone through. Can everyone here agree to do that, or at least do their very best? Big loud yes?
Yes.
All right. Now, to the other side, has anyone here been accused or a close friend or family member been accused of crimes like these? No, okay. Now, one thing that is rather important, and this is for any jury trial, is that legal terms don't always mean the same thing they do in English. Legalese and English, while they use the same words, very different languages. And so part of what happens in a trial is that when you're set back to deliberate, you're given a very thick packet of jury instructions that define certain terms for you, that the judge gives to you. A good example I always use is that when we hear the word assault, juror number 4, what comes to mind when you hear the word assault? I'm going to tell you right now.
Force.
I'm going to tell you right now, you're juror number 3.
Sorry, the number, sir.
This says 4 in front of me.
Oh, no. You are number 3. But anyways.
Okay, sorry.
Contact being made, right?
Yes.
Force being applied to somebody.
Yes.
So that's what I always thought it was. That's what everyone thinks it was, because that's what it means in English. However, in legalese, that's not an assault. An assault is you try and hit somebody but fail, or you try and make them think you're about to get hit, you know, holding back and making them flinch. Actually making contact with someone is a battery. It's weird, but that is what happens with a lot of legal terms, especially when it comes to crimes. So, can you all agree to use these terms as the judge instructs you to use them and not how we've grown up with them our entire lives using them?
Yes.
All right. Now, some people don't agree with what all the laws are on the books. I may not agree with some of the traffic laws that are in our fine city, but we are still required to abide by them. I say this because for cases involving domestic violence, there are some people who believe that it's not the court's job or the law's job to get involved with that. That's a private matter, a family matter. But you still have to follow the law as the judge gives it to you. Can you all agree to follow the law as the judge instructs you on, and not what your own personal feelings on the law might be?
Yes.
By show of hands, who here has had prior involvement with law enforcement? Any involvement, but I'll go through the line here. Okay, juror number, I'll let everybody. All right, juror number 1.
I have a brother who is in law enforcement.
Where's he at?
He's in the state of Indiana. He is the chief deputy marshal of the U.S. Marshal Service for the northern half of the state.
Oh, you know, just a small area. Well, some of the witnesses in this case are going to be law enforcement. Because of your family connections with law enforcement, does that mean that you're going to be more biased towards the police in this case?
Yes, probably.
Let me ask it this way. When you hear a police officer testify, can you agree to put that aside and view their testimony as you would anybody else working any other job? If you can't, that is okay. Like I said,
Yeah.
honesty, there are no wrong answers here.
Yeah, I lean toward the police, I do.
That is fair, and that's why I ask these questions. So thank you for letting us know.
Can you be fair and impartial to both sides and listen to the evidence?
I could listen to the evidence.
Okay, so if I ask you to make a decision right now, are you going to vote? How are you going to vote?
How would I vote?
Yes,
I lean toward the police.
which means you vote guilty?
I know you're not guilty until proven in, I mean,
So you
innocent
can-
until proven guilty, yeah.
Okay, so when you listen to a police officer's testimony, and look, we've all seen the news, there are some good cops and there are some bad cops, right?
Yes.
So can you listen to the officer and determine the credibility or lack of credibility of that officer? Or regardless, do you tend to weigh more heavily on that? I mean, with each witness, you're all going to have to decide if they're credible or incredible or not credible, right? So you can't pre-decide. So can you do that or not?
I don't know if I can. I really don't know if I can.
So you.
Just because, yeah.
Yeah, you lean that heavily on law enforcement, show the people are already coming out ahead. In this case, you haven't even heard anything.
Yes.
All right, I think that's cause.
I think it is too.
No objection, Your Honor.
Thank
Like I
you for
said-
your honesty, sir, appreciate that. I'm sure law enforcement does too, but you are excused. We need everyone to be fair and impartial to both sides. You're
Like I
excused,
said,
sir.
you might be a great juror in a civil case.
Yes. Unless it's against the police department.
Yeah.
All right. All right, thank you. And council, we now have juror 272 is here. All right, and as to filling juror seat 1.
Full sequence number 272.
272?
Yeah, you just give it a bag. Yeah. Just 272, seat 1.
Hello, new juror. I'm glad you're able to make it with us. Now, I've got a couple preliminary questions I want to ask you before I get back to what I was asking people, okay?
Yeah, I don't speak a lot, I don't understand a lot about English.
Sir, so English is your second language?
Yeah, second language.
And so you have trouble understanding?
Just a little bit, I don't understand about English.
Okay, I think based on the language barrier. Sir, you're excused. Any objection?
No, Your Honor,
Thank you
thank you.
thank you for being here, sir. You're excused.
You're good.
All right. I didn't ask that about the whole group. Does anybody else have a barrier to understanding English? Seeing no hands raised, I take it you're all residents of Ingham County? Or Michigan, yeah, okay, good. All right, as to juror seat 1.
Full sequence number 404.
Thank you, sir. You are now juror 1. Counsel, when you're ready, you may proceed.
Thank you. Okay, I'm going to keep going down the line here and then I'll get back to you. Juror number 2. What involvement with police have you had in the past?
My uncle is also a U.S. Marshal. That was convenient.
Is he also in Indiana?
No, he's in Ohio. And his daughter, I know, right? His daughter is a police officer and his other daughter, I guess he's got 3 daughters. One of them went into the army and was a sergeant. I know it's not police. And then the other one is in corrections.
Okay, are any of them Michigan? Are they all Ohio?
They're all Ohio.
Okay. Now, would you be able to still give the same amount of weight to a police witness as you would a lay witness, someone who isn't a police officer? And I'll just preface this by saying, what we're looking for is not to, again, not to be a blank slate, but just to view their testimony as you would if they had picked any other profession. You know, the same if they were a bank teller, so they were a cop, you're judging their credibility. So all we ask is that even if you are biased to or against the police, you're able to kind of set that aside and just view them as a person with a job. That's what it boils down to. Now, juror number 3. What has been your prior involvement with law enforcement?
We had to call law enforcement to our home because of an attempted breaking in our truck. It was a very positive experience.
How far back was that?
3 or 4 summers ago.
Okay. Now, this is a case that does involve a count of home invasion. So, given what you guys went through that day, are you going to be able to keep separate what happened to you versus what happened to Alyssa?
Yes.
Juror number 4?
Traffic stop. My lights were off. She had me turn them on, checked my license, and sent me on my way.
Okay. That make you biased at all to or against the police?
No, it was a pretty neutral experience.
Juror number 5?
Yeah, handful of traffic stops and one department had some consequences.
Did that make you biased in regards to a police officer being a witness?
No, it did not.
Juror number 6?
Yeah, just a couple of times being pulled over in my life, and then I do have a couple of family friends that are in law enforcement.
So the fact that you have family friends in law enforcement, does that make you more inclined to believe a police officer as opposed to any other person?
Yeah.
Juror number 7?
My ex-husband is former LPD in St. Police Department.
Okay, and how are we talking? Are we talking the last couple of years or? Okay. Now, the fact that you have ex-husband who's an LPD and there will be an LPD detective testifying at some point, is that going to make you any more biased for or against the police?
No.
I am struggling to remember who raised their hands on this from a bit ago. I'm going to go down like juror number 8. Have you had any prior involvement with police?
No, not really. My grandson's a police officer, but
Where at?
in Ingham County Sheriff's Office.
God, now we also have someone from Ingham County Sheriff's Office who's going to be testifying. I believe that is Trooper Darby. I take that back. He's state police. But the fact that your grandson's in law enforcement, is that going to make you biased for or against the officers when they testify?
Out of
Okay. Juror number 9. Have you had any prior involvement with law enforcement?
No.
All right. Juror number 10? Juror number 11?
No.
Wow, I really remembered wrong. Juror number 12?
Several speeding tickets. My dad was state police. My mom worked for the state police. She worked for, I don't know what she worked for. She did like building and tearing down computers for state police. My aunt's the judge, my uncle's the judge.
What?
My aunt is the judge, my uncle is a judge now, I think.
Where are the judges at?
Up in Arizona.
Okay. Sorry, that threw me there for a second. So you have family who are in law enforcement. We will have Trooper Darton from Michigan State Police. Does the fact that you have family relationships with law enforcement make you biased for or against them when you hear them testify? Juror number 13.
Mine is a professional connection. I have spent about half of my career working inside the Ingham County Jail, providing behavioral services and supervision here.
So given the fact that you've worked with the corrections department for a good chunk of time, even in a support role as opposed to hands-on with inmates, does that make you feel biased for or against law enfortement if you were to hear them testify?
No.
And then finally, juror number 14.
2 traffic stops, 1 ticket in the 80s. And one time someone threw a rock through my window, and so we recorded it, but it was a very neutral, that was not a rock. So, I mean, we did file a report, but that's all that happened.
All right, so safe to say you're not biased for or against police then, because of that?
No.
All right.
That's a yes.
That's a no.
Yes, I do not feel biased about testimony.
Okay. I said finally, but juror number 1. Have you had any prior involvement with law enforcement?
No.
Has anyone here served as a juror before? By show of hands. Okay, I'm gonna ask you guys a couple of questions. I need to say this up front because it's one of those bright red lines. If you reached a verdict in your prior service, I want to know if you did or not. I do not want to know what that verdict was, okay? I've had some people blurt that out, which is why I have to put this up ahead of time. So let me see those hands one more time for prior service. 3, 8, 10, and 14. Juror number 3. How long ago were you serving on jury?
8 to 10 years ago.
Do you remember if it was criminal or civil?
Civil.
And were you guys able to reach a verdict?
Yes.
Okay. Juror number 8. How long ago did you serve as a juror?
Probably 15 years ago, and yes, we were able to reach them.
Was that criminal or civil?
I had one for criminal and one for civil.
Well, thank you.
And both sides.
Thank you. Juror number 10. How long ago did you serve as a juror? Ballpark.
2014, 15.
Or don't ballpark it, 2014 to 15. So were those criminal or civil?
Criminal.
And were you guys able to reach verdict?
Yes.
And then finally, juror number 14. How long ago did you serve as a juror?
About 30 years ago.
Okay. See, that's ballparking. Was that criminal or civil?
Civil,
And were you guys able to reach a verdict?
yes.
Perfect. Now, one of the big things that a lot of jurors have difficulty with in serving as a juror is in regards to possible penalty. You all as jurors will not know what the possible penalty is for these crimes. That's because it is not up to you to decide. It is up to the judge and the judge alone. Your job is to decide what happened, and the judge's job is to decide what should happen. But I get that makes a lot of people uncomfortable having to decide a rather important thing without knowing what possible consequences there may be or implications there may be, one way or the other. So, does anyone here feel that you'd have difficulty coming back with a verdict of guilty if you didn't know what the possible penalties might be for the defendant? No one. Okay. Now, another reason that a lot of people have difficulty serving as a juror is because it requires you to judge someone. It requires you to judge a fellow member of your community. And some people have either strong religious beliefs or strong personal beliefs that is not my job. It's not my job as a person to judge someone else. That is for a higher authority, a higher power to do. Does anyone here feel that they have such a strong religious or personal conviction that it would make it difficult for you to judge someone in your community?
No.
All right. What I also hear a lot is being unable to decide because you're afraid of making the wrong call, making the wrong decision. I want to be clear. You will not be 100% certain about what happened that day. No jury ever will. The only way you can be 100% certain about what happened is if you were there. And if you were there, you wouldn't be in a jury box. You'd be on my witness list, being read off to a different jury. The standard in criminal cases is beyond a reasonable doubt. Not beyond all doubt, just doubt that is reasonable. When you're back deliberating and you're thinking, well, maybe it could have been this. Maybe it could have been a different situation. Maybe it could have been an evil twin, or maybe it could have been, just some complete misunderstanding. You have to ask yourself, is that reasonable? Is the doubt, that intrusive thought I've got in the back of my head on this, reasonable to have or not? Because we're not saying you can't have unreasonable doubts. People have those about everything every day. Just beyond any doubt that's reasonable. Can you all agree to hold me to that standard, approving this case beyond any reasonable doubt, not beyond any doubt whatsoever?
Yes.
Now, to that point, my job is to prove the elements of these crimes beyond any reasonable doubt. There are a lot of charges here. If I'm going to use probably the simplest one as an example, that's going to be count 6 domestic violence. Elements of domestic violence, pretty straightforward. Did an assault or battery happen? Was there a domestic relationship? That's it. Those are the 2 elements that I have to prove. What I don't need to prove is what hand was used in the assault. I don't have to prove what color clothes that he was wearing when he assaulted her. I don't have to prove whether it was raining or sunny out. I don't have to prove if it was in the living room or if it was in the bedroom when it happened. Those are facts important, but they're not the elements of the crime. So if half of you think, well, he assaulted her with his left hand, half of you think, well, he assaulted her with his right hand, but you all agree the assault happened. You all agree that I've proven it beyond a reasonable doubt. And you all agree that I've proven they were in a domestic relationship. Your job is to come back with a verdict of guilty, even if you don't know which hand was used. It was a closed fist or an open palm. Because my burden is to prove the elements, not every fact about an incident. You all agree to hold me to that burden and not more than that.
Yes.
Now, the law doesn't require me to use any specific types of evidence to meet that burden. It doesn't require me to show you video of the assault or photos of injuries or have eyewitnesses around. It doesn't give me any specific requirements for proving that. Can anyone here think of why that is? Let me ask you guys this. Who here thinks criminals like to commit crimes in front of other people?
Not very good.
Why do you think that might be?
They want to hide.
Because they want to hide what happened. Who here thinks they're going to try and commit crimes in front of a security camera? No, because most criminals would like to get away with their crimes. Is that safe to say? So can you guys understand that that's why I'm not required to have a certain type of evidence to prove guilt beyond a reasonable doubt?
Yes.
Who here has ever seen shows like CSI? By show of hand, NCIS, things like that. Okay, almost everybody raised their hands. You guys think that's how these cases actually work in the real world? Do you guys think that there's always DNA in every crime scene that's ever existed? There's always fingerprints everywhere. Is anyone expecting this trial to be like a TV show? One of the crimes here is criminal sexual conduct. It's what we colloquially refer to as rape. There is a specific law that you'll be instructed on that to convict someone of rape, sexual assault in the state of Michigan, I am not required to present anything beyond the victim's testimony if you believe that her testimony has proven it beyond a reasonable doubt. If you believe after listening to her talk about what happened, looking at her critically, not just taking it at face value, but analyzing what she's saying and how it lines up, you come away believing that her testimony proves that charge beyond any reasonable doubt, your job is to come back with a verdict of guilty, even if that's the only evidence I bring to you. That's the law the judge will instruct you on. But I get that that can make some people uncomfortable. So, does anyone here think they would have difficulty following that law?
No.
One of the other things that I don't really talk about on TV is that there are a lot of rules when it comes to a trial, specifically regarding evidence. There are going to be things that you as jurors will never see before making your deliberation. And what's worse is you will not know what you're not seeing. You will not know what exists that you are not seeing before you make your decision. Because the rules are there to ensure that each side has a fair trial, both the defendant and the people. Show of hands, who here would like to see the police report before making that decision about whether or not these crimes happened? Who here thinks it would be helpful to making your decision? Okay. That is one of the things that you will never see. No jury will ever see a police report because it is not allowed as evidence. Obviously, every jury would like to. Every jury thinks that it would help them, and it might. But the rules of evidence are there to make sure there is a fair trial for both sides. Can you all agree to make your decision based on the evidence that you have at the end of the day, and not the evidence that you wish you had?
Yes.
Your job as jurors is to decide what happened, and my job is to make sure that everyone's rights are protected, both the people's and the defendants. Because I represent the people of the state of Michigan. And despite being charged with crimes, he is one of those people. My job is not to find 14 jurors who are going to agree with me. My job is to find 14 jurors who are going to be impartial. We're going to be able to look at this in an unbiased way. Because the defendant has a lot of rights in a trial. I mean, the biggest one is the right to have one. If I wanted to truly run my life into the ground in a spectacular fashion, I could walk over to Mr. Freeman and I could punch him in the face in this courtroom. I would be tackled immediately to the ground, not only by Kayla there, who would absolutely take me down to the ground, my own detective guards, and I'm assuming half the courtroom. Definitely Brian. I'd be immediately handcuffed, arrested, and charged with assault and battery. And I would have the right to plead not guilty and to have a trial and be in that chair while another jury is being picked for my case. Because the right to have a trial is absolute. It's not about how much evidence there is. It's not about what the charges are. It is everyone's right. I could assault someone in front of law enforcement, a judge, cameras, a room full of jurors, and I'd still have my right to be right here with another jury being picked for a trial. As you've already heard, the fact that he is charged with crimes, and 18 crimes, does not mean he is guilty of that. It does not go to the weight. It is not evidence. By that same token, the fact that we are having a trial at all does not mean anything one way or another in regards to guilt. Because it's everyone's right in this country to have one. Does everybody understand that?
Yes.
One of the other rights that every defendant has is the right to not testify. It is not the defendant's job to put on the case. It's my job to prove the charges beyond any reasonable doubt. If Mr. Freeman decided to not do anything in this case, but just pull out a pillow and nap through the entire trial, and I don't give you enough evidence to prove it beyond a reasonable doubt, your job is to come back with not guilty. Your job is not to decide which side here did a better job, which side put on more witnesses or admitted more exhibits. It's at the end of the day, when you're sent back to deliberate, is there enough evidence for you to prove it beyond a reasonable doubt? Can you all agree to hold me to my job?
Yes.
Now, part of this trial is going to involve you listening to Alyssa Clark tell you what's happened to her. She's going to sit in that chair and look at you all and tell you about several of the worst days of her life. I don't expect it to be easy for her. Does anyone here have any expectations of what a victim of domestic violence, sexual violence looks like? Does anyone here have any expectations of what a domestic abuser looks like? Juror number 6, why not?
Anybody could like commit like a crime, I guess, so.
Right.
Yeah, so no expectations of what this should essentially look like.
Exactly. Domestic violence can be committed by anyone on anyone. So let's try something here. By a show of hands, who here has been in a car accident so bad the airbag's deployed? Okay, 2, 3, 9. Juror number 9, I'm gonna pick on you here for a second. This is Michigan, so was it a deer or a driver?
A deer.
How did you react like immediately after that happened?
I was in shock, kind of freaked out.
Did you react the way you thought you might act in that situation?
I didn't know how I was gonna react. It just never happened. I was scared.
Do you think that everybody reacts the same way in that situation?
Maybe initially.
Is it safe to say that people respond to trauma differently?
Yeah.
Does everyone here have any expectations about how a victim of this type of trauma should react to it? By show of hands, who here thinks it's common for a victim of domestic abuse to go back to their abuser? If you were to hear Alyssa tell you that she went back to him after he put his hands on her, would anyone here be less likely to believe her about the fact he put his hands on her? If you were to hear that she waited to report what happened to her, would that make any less likely for you that it happened to her?
No.
Specifically the sexual assault. If she were to tell you that at times they had consensual sex, that make you not believe her when she says that this time they didn't. Does anyone here have any difficulties with the concept that you can be raped by someone you're in a relationship with? Even if you've agreed to have sex with them before. Does anyone here believe that if you're unconscious, you can consent to sex acts happening to you? Does anyone here believe that there needs to be evidence of resistance and kicking and shoving in order for a person to have been raped? Now let's just take some of the broad strokes here. Let's say you've listened to Alyssa tell you about these crimes, tell you what happened to her. And you come away believing her, but you do not like her as a person. This is not someone whose choices you agree with or approve of. This isn't someone you'd want to be around your family or to be living on your block. Will you still believe these crimes happened to her? You still going to come back with a verdict of guilty?
Yes.
Let's say the opposite. Let's say you really do believe these crimes happened. You like the defendant. You think that, hey, maybe this is just a dark time and he's really good. He's like a pillar of the community. He's someone you'd want to have around. You do believe that he did these crimes on these days. He's still going to come back with a verdict of guilty. Yes. Flip side of that. Let's say you don't believe when Melissa's testifying about what happened to her, you don't believe it proves the crimes beyond a reasonable doubt, but you like her, you feel for her, you want to give her a hug, but you still don't think the evidence is there. Are you guys going to come back with not guilty? If you don't believe the evidence is there, but you like her, because that's your job, right? Just figure out what happened, not based on how much you like a person. You all agree to follow that job.
Yes.
I think I jumped away from this. Apologize, it's been a long morning already. The defendant doesn't have any burden in a trial. It's the people's burden. The defendant only has rights. The right to have a trial, the right to see every piece of evidence that we have, the right to subpoena any witnesses they may want to come to trial, but also the right not to testify. I mean, that's everyone's Fifth Amendment right. And you'll be instructed by the judge, but I want to make crystal clear here. That's not to be taken into account when you're deliberating. So if the defense decides to exercise his right and not testify in this case, is anyone here going to hold it against him? Is anyone here going to have that affect your view of the evidence?
No.
Can you all agree to make your decision based on the evidence you have and the law that you are given by the court?
Yes.
Is there anyone here who has any reason, any concern in their head that I haven't talked about or the judge hasn't talked about why you may not be a good fit for this jury?
Maybe I should talk to the judge about it.
Yeah, that's juror number 10. I don't have any questions, but maybe that would be a good moment for a break then.
All right, let's take a break.
All rise. You may all be seated.
Juror 10, what would you like me to know?
Hi, about a week ago, took my son in, he had a suicide scare, we took him to a public place. Just for a part of the day, he got assessed, looks like he's in pretty good shape. And I think he's fine, but I want to let you know that if something were to happen, I probably wouldn't attend the trial if I take care of my kid. Right? And that, not out of disrespect to you, but just I feel obligated to that.
Totally understand.
I mean, if he's fine, I'd be fine being here, but I just would feel like I want to let you know that so I don't just disappear one day if he has to take care of business. So it's up to you. What do you want me to do?
Well, let me ask you this. I see a lot of this. I know a lot about this. There's things you have to do in your home, medication, knives, all that stuff. And you may need treatment. There's a lot going on. And as a parent, it weighs heavily on your mind, like what's going on in your way, especially so close to the incident.
Right.
Okay. I need 100% of your attention. And this is very complicated. You know, there's a lot of charges and all of that. Are you going to be sort of halfway paying attention, halfway wondering, is my kid okay?
To be fair, I think if things are as they are today, I'd probably be okay. But if something were to deteriorate, I would probably struggle with that. You know what I mean? Like,
Yes. So is he in school? How old is he?
he's 12 and we pulled him off the last 7 days of school. So he's at home with my wife and then he's out and then school's over like 3 days or something. So
Right. Is your wife then with him? I mean, does he?
yeah,
Okay.
my wife is home with him. Yeah.
I mean, if something happened, we certainly wouldn't expect you to show up. We would
Right,
expect a
right.
phone call, that's it. But I hope that doesn't go down that road, but I also, you know, I know that extra stress.
Yeah.
Counsel?
I would be fine with 4 o'clock here. Genuinely, I
I have no objection to the gentleman being excused. Thank you.
All right. I just wanted to let you know in case. So.
Yeah, and I appreciate that. The issue would really be your comfort level and your, you know, my motto here, even with my staff, with everything is family first.
Yeah.
So that has to count. So I
Thank you.
think you're better off being at home and
I appreciate
dealing
that.
with this issue. So it's
All right.
very complicated. So, and I hope this isn't the case, I don't need to know anything, but certainly if he's being bullied or there's some stuff going on at school, please reach out.
We have, yes.
Yeah, there are agencies that can help, and there are charges also that can be filed, so.
Right.
Courts and prosecutor's office can help you, so.
Thank you.
So please let us know if we can do something.
Right.
You're really.
Thank you. Thank you.
Record awaiting the jurors who are ready to come in. I understand there needs to be another record as well as Brian checked with the jury clerk, and 189 was actually wrong. The number, it was actually 303. So they have, everybody is present and accounted for, so there'll be no bench warrants based on the juror numbers.
Got it. So the issue that we just want to make a record of preemptively, as the public defender's office has done in prior trials, where, as I say, it's not exactly a Batson challenge, but it is making a record of it there that the jury pool is very, very white when the defendant is not. And so the record I just want to make here is that is what it's looking like now. It's not what it looked like at the start. And because that kept happening, I kept track. It looks like there were 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 jurors of color who were dismissed in your questioning before the people even got to any of the questioning.
For cause.
All for cause. And then there were 2 more for cause, both that were ended up being juror number 1 at the beginning of my questioning. So I'm just making there to be a record because I don't know what's going to happen here or who I'm going to feel that I need to use my preemptive challenge for. But I just want to make sure there is a good record here that the jury pool has now gotten significantly less diverse after judge questioning. While it's not anything depriving of rights or anything along those lines, in preemption of any potential Batson issues down the road, I just wanted to make that record now.
Okay, and I have not looked to see if there's any minorities left or not, but certainly Batson challenge record is always good to make. Counsel?
Yes, Your Honor, thank you very much. I appreciate the comments offered by Mr. Pfeiffer. I did not count non-whites from the pool. Is that what you're using as pool?
Yeah.
Okay. And I am also aware that the current state of our law is that it matters not whether a person of the same origin as my client was called to the witness box. It just matters whether they were part of the pool. And so long as there was a representative sample in the pool, I don't believe there's merit in challenging based on Batson. Thank you.
Well, and I believe I have to see how many actually reported, but we requested 120 jurors, and they actually got me 124 jurors because of so many charges that we knew we would lose many. So there was originally a very good pool and a very good mix, but through no fault of anybody, we have lost those numbers. I have no idea how many are left. So let's proceed, and then if you need to make a further record, we will.
Thank you, Your Honor.
Thank you. The jurors, please. Thank you. You all may be seated.
Your Honor, can we approach very briefly?
Yes. All right, thank you. Mr. Freeman is going to be asking questions, and juror 10 has been released, so we will fill juror 10's seat after Mr. Freeman is done. Mr. Freeman, you may proceed.
Thank you, Your Honor. Good afternoon. Juror in seat number 3. I understand you're a teacher.
Yes,
Do you mind sharing with us what grade and where?
7th grade science, Hope Public Schools.
Thank you. My first set of questions are really easy. It's just to touch base on qualifications. If there's anyone currently seated who does not live in Ingham County, please raise your hand. I see no hands raised. Everyone lives in Ingham County. Thank you. If any of you are 70 years of age or older, it's not necessarily disqualifying. You may serve as a juror, but if you prefer not to, you could possibly be excused. Anyone in that category? I see no hands. Thank you. During seat number 13, you saw how many folks were excused early on.
Yes.
And my memory, it may be yours, it may not. A great many of them said, boy, 18 counts, I just don't know. I can't be fair. And I take it that because you're still seated, you believe that you can be. Is that true?
Yes.
Thank you. I want to explore other possibilities other than the number of charges pending. Okay. Can you see my client, Mr. Brooks, from where you're sitting?
Yes.
Can you see his head here?
I can see his hair in the front.
Yeah. Can you see it?
Yes.
Thank you. Can you see his facial hair?
Yes.
Does he appear to you to be, look like someone who could commit these kind of crimes?
I don't know what somebody would look like that would commit any crime.
As you can see,
So,
I'm
no.
wearing a hearing piece, so.
I don't know.
Okay, thank you. Is it fair to say you can't tell just by looking at someone?
Correct.
Thank you. Let's see. You're in seat number 4. You know a little bit about baseball?
Honestly, not a whole lot. I know there's.
All right. Well, I appreciate your honesty. You're in seat number 1. You know a little bit about baseball?
Not really, no. Not a sports guy.
Who knows a little bit about baseball? All right. You're in seat number 6. Thank you. If a batter hits the ball that's pitched to him and it sails over the left center field scoreboard, is that a home run?
Yes.
What if the hitter, the runner, does not touch second base? Is it a home run?
No, he has to touch all the bases.
All right. I chose that simple example because I believe that the thrust of this trial will be all about this ball going over the left center field scoreboard. But if you don't touch all the bases, it's all for naught. Does that make sense to you?
Yes.
All right. And you're going to hear more about this from the judge at the conclusion, but the idea here is that each of the 18 charges are made up of parts called elements. And it is not enough for the prosecutor to simply allege that these crimes were committed. He has to touch every base. He has to prove each and every count and each element beyond any reasonable doubt. Can you appreciate that?
Yes.
Would you hold him to that standard?
Yes.
Thank you. I can't be sure exactly of the order of witnesses or the amount of evidence that is going to be brought your way. But, and if you don't mind, I'll continue with juror number 6. If you and I are standing out in the parking lot, and I tell you the moon is made of green cheese, we're just talking. If I come in here in this courtroom, judge asks me to raise my right hand and I swear to tell the truth, and if I sit in that chair and I say the moon is made of green cheese, that's evidence that the moon is made of green cheese. It's testimonial evidence. You're free to accept it or reject it, accept part of it, reject the rest, whatever you believe is appropriate. Does that make sense to you?
Yes.
Okay, thank you. During seat number 9, may I ask you, whenever it may have been, and perhaps never, but have you ever been stood up for a date?
No.
Good for you. Any female who's been just stood up for a date, could have been back in high school, college, anytime? No? Okay. Well, in that case, then, I'm going to respectfully ask juror number 8. You could appreciate, I trust, that if that did happen, there'd be some emotional feelings attached, at least initially. Okay. And if we take that a step further, and you discover that your husband or your boyfriend was sleeping with your best girlfriend, and soon thereafter, you made these allegations, would that have any impact on the veracity of the truthfulness, or your concern as to whether that testimony is credible?
Repeat that question.
Sure. What I'm trying to get at is whether, in your opinion, and just based on life, okay, if someone calls 911 and wants to report a crime, whether it is significant, the circumstances surrounding placing the call. If the female placing a call to the 911 had just discovered that her boyfriend or ex-boyfriend, husband, was sleeping with the woman's best girlfriend, might that influence your opinion as to the credibility of those complaints?
Yes.
Anyone who would not be affected, raise your hand, please. I see no hands raised. Thank you. I believe we're going to hear some testimony about obsessive compulsive disorder, OCD. Anyone afflicted with that particular disorder? I see no hands. Anyone know someone, a family member, a close friend, somebody at the office who is afflicted with that? Anyone? Yes, I see, I think 3 hands. Juror in seat number 13. I'm not asking you for a name, but is this a family member or a friend?
No, professionally.
Okay. And have you come to an understanding as to whether there are typically symptoms associated with that disorder?
Yes.
Okay. If you know, and if you don't, just say, I don't know. Do you know whether there are medications available to help with that disorder?
There can be some, yes.
Okay. Thank you. I believe we're going to hear some testimony too about post-traumatic stress disorder, PTSD. Anyone affected with PTSD currently seated? I see no hands. Anyone have a family member, close friend, neighbor, somebody at church, somebody at the office who is afflicted? Juror in seat number 14. I'm not asking for a name. Can you help me understand the relationship between you and this person?
I have a sibling who is a military veteran.
It's not you, it's me. Pardon me?
I have a sibling who is a military veteran.
You know anything else about that disorder?
I have read a little bit about it, and then if he decides to speak about it with me, then, but I understand that, I mean, that's his particular experience.
Okay.
I wouldn't claim to be an expert at all.
Did I see another hand raised? Yes, you're in seat number 5. Oh, excuse me, 2. I'm going the wrong way. Seat number 2.
Mine's actually the same circumstance. My brother was in the army and he's also afflicted.
Have you done any research or spoken to him with respect to the symptoms of that disorder?
Minimally.
Okay. What's your understanding as to the common behaviors or symptoms involved?
It's a broad range. Could be anything, depending on the individual's experience.
And by that, is it your understanding, and I'm not asking you for a medical opinion, but is it your understanding that post-traumatic stress disorder typically sets in after a particular experience or multiple experiences? Thank you. You're in seat number 11. I get caught up on this one sometimes. If you were on trial, if you were sitting in the seat that Mr. Brooks is currently sitting in, would you want someone like you on your jury?
Oh, yeah,
Is that because you believe you can be fair and impartial?
yes.
I'm also asking you because of your gender. Is it likely you could feel some sympathy, some empathy, some pity for a female whose testimony consists of things the prosecutor claims is torture?
Sure.
Would you nevertheless be able to, in your mind, judge credibility?
Yes.
You're in seat number 1, 2, 3, 4. You're going to hear from time to time this word believe or believable. Okay. Would you be okay substituting the word reliable for someone's testimony reliable, regardless of whether you believed it?
I'm sorry, could you repeat the question?
Sure. I'm trying to get the point across, and I'm just asking if you agree that instead of believing what someone's saying, okay, you found for other reasons that what they told you was credible, whether you believed it or not.
I suppose so.
Okay. Still, is it my question that's either?
I suppose it would depend on the situation.
Oh, of course, sure.
But yeah, I suppose so, yeah.
Okay. There were, I think, 3 of you who raised their hand when counsel asked whether you had ever served on a jury before. Jury number 14, I think yours was a civil trial.
Correct, yes.
Who were the other 3, if you don't mind? Thank you. Jury number 8, that was a criminal matter.
Yes, it was.
And again, I'm not asking you what the verdict was, but my memory was that you said that the jury you were on did reach a verdict.
That is correct.
All right. Do you recall whether that was a case involving torture?
It was not.
Was that a case involving criminal sexual conduct?
No.
Was it a case involving any of the allegations Judge read to you earlier?
No, it was not.
Okay. And I'm sorry, I lost track. Thank you. Juror in seat number 3, my same questions. It was a criminal case?
No, I was civil.
I'm sorry?
Civil.
Oh, okay. Was there one more person previously sat on a jury?
It was 10 in each.
Okay. Thank you. Juror in seat number 8. I take it that when you arrived here this morning, you didn't know anything about the case, anything about who's involved, or is that a fair statement?
Absolutely, I didn't know anything about it.
All right. Did you also walk into this room with a personal belief that trials are about finding the truth?
Yes. And the evidence.
And how is it that you're able to, either how did you develop that, or why do you think trials are all about finding the truth?
The basis of our democracy. I'm sorry, the basis of our democracy is having a fair trial. And everybody deserves a fair trial.
I couldn't agree with you more.
On the other hand, you have heard, I'm sure, on the news or read in the paper about folks who, 20 years and he's released, he's exonerated, the DNA shows it wasn't him. That trial didn't have a whole lot to do with the truth, did it?
Well, it did have a lot, and the truth was there.
Well, all right, but nevertheless, in an example like I've just shared with you, not with any individual particularly, but that person was charged. That person had a trial. That person was convicted, and that person was sentenced. And it wasn't until, typically 15, 20, 25 years later that, oh my goodness, we have additional evidence or the DNA shows it wasn't him at all. Right. And they don't say that that person is not guilty. They say he's exonerated. Is that a term that you've heard?
Yes.
All right, thank you. So again, you continue to believe that trials are about the truth?
Is that a yes?
Yes.
The complaining witness in this trial is a Miss Clark. I think you'll see her Monday. You're in seat number 7. If Ms. Clark, or frankly anyone, makes a statement to law enforcement on this day, and then later makes essentially an identical statement to a follow-up detective, testifies at a hearing in the lower district court, and they're pretty consistent, okay? Can you imagine any reason whatsoever why someone would come into a circuit court trial and change their story?
I can't think of one off the top of my head.
Okay. It would be expected, would you agree? It'd be expected that.
There would be consistency, yes.
Okay, thank you. You're in seat number 2. You're a scientist?
Yes.
Excellent. Can you help me understand with a little more particularity?
So I actually just got a new job, but it's still in the realm of science. I was testing heavy metals in blood and urine for the state of Michigan. My new job is a chemical threat coordinator where I do outreach with hospitals and hazmat teams to make sure that they keep the state of Michigan lab in mind in chemical exposure events, large scale.
The Michigan lab, are you referring to the Michigan Department of State Police Crime Laboratory?
No.
You have not had any affiliation as a scientist for the Department of State Police?
No.
All right, thank you very much. You're in seat number 1. I think your information sheet suggested you're manager of a restaurant?
Yes.
Here in town?
Yes.
How long have you been in that position?
About 8, 9 years.
Whether it was Mr. Pfeiffer's question or any of the ones that I offered thus far, would you have answered in a particular way that we should know about? Seat number 8, you're retired. Do you mind if I ask from where?
From Hope, Michigan.
You work for the township?
I work for the state of Michigan.
I beg your pardon. And I think you just said that again. I'm sorry. In what capacity?
I was a professional buyer.
Thank you very much. Sure, number 9. You're in the medical profession, is that right? Okay. I suspect strongly that there may be some testimony from more than one witness about physical injuries. Okay? If you continue to be on our jury and you are back with 11 others deliberating, would you feel as though, given your profession, you have a louder opinion, for example, as to any evidence that's offered in this trial with respect to injuries?
Medically, I might have a better understanding.
Okay. Okay. Let me just ask you one specific question. What is a bruise?
What is a bruise?
What is
Something that's caused by force, hitting, running into something, a mark on the skin.
And regardless of ethnicity, is that typically something that develops immediately?
If they're hit hard enough, probably, yeah.
Okay. As a registered nurse, are you able, based on your education and experience, would you feel comfortable rendering an opinion, looking at a bruise and saying that bruise is X hours old or X days old?
Days maybe, but not like specific hours. You can tell when something's fresh versus old
And how would one do that?
by the coloring of it.
I'd like you to answer, but I'm tempted to. What about the darkness of the bruise? Is that significant in terms of telling you how long it's been there?
Not necessarily.
Does it indicate anything as to the trauma that was inflicted?
Like the force of,
Yeah.
could be.
You're in seat number 13. I should know myself, but I think you indicated your profession is a behavioral health supervisor.
Yes,
Briefly, could you help me understand a little bit more about that?
yeah, I work for community mental health, I supervise behavioral health services. I'm a director of our programs that houses our substance use services, some of our healthcare integration services, and all of our correctional based services in the Tri-County area.
Okay, thank you. And community mental health, are you a county employee?
No.
Do you know anything at all about this case before you walked in this morning?
No.
Thank you. Okay. I think that's all I have, Your Honor. I'm just double checking. Yeah, just the last question is just of general nature. If any of you believe that you probably shouldn't serve on this jury, maybe a different jury, you're feeling uneasy or awkward or not comfortable in the current shoes you're wearing, could you raise your hand for me, please? I see no hands raised. My thanks to the court.
On behalf of the people for cause,
None for cause, Your Honor.
on behalf of defendant for cause,
No, Your Honor.
on behalf of the people peremptory and made multiple.
Your Honor, at this time, people would like to thank and excuse juror number 11.
Anyone else?
That's it.
Thank you. On behalf of defendant, at this time, sir, you're excused. Thank you very much. On behalf of defendant, anyone?
Your Honor, if I could have just 15 seconds.
You may.
Thank you. Your Honor, the defense, and thank you for that moment, the defense would like to thank you, respectfully excuse prospective jurors in seat 2, 6, and 7. Thank you.
Thank you. 2, 6, and 7, you're excused.
Good afternoon. All right, these questions are only going to be for the new additions to the jury pool, or to the panel, I'm sorry. Now, I know that you guys were listening to what we asked before. There are some questions where I simply have to ask again. I wouldn't be doing my job if I did. But from the jump, is there anything that you heard us talk about that you feel they have a really strong opinion on that you feel that we should know, serving as a juror?
No.
Okay. Because of the graphic nature of this type of case, do any of you feel that listening to Alyssa tell you about what happened to her in detail would make you so uncomfortable it would be difficult for you to sit through this trial and pay attention to the evidence that's coming in?
No.
Juror number 7, sorry. Is that no?
No.
Have any of you, either yourselves or a close friend or family member that you're aware of, been the victim of domestic violence, domestic abuse? Juror number 10. Who do you know who is the victim of this type of abuse?
Me.
And how long ago was it?
2 years ago.
Okay. Now, given what you went through back then, are you going to be able to sit here and listen to Alyssa tell you what happened to her and keep separate what happened to you?
Think so, yeah.
Okay. And juror number 7, who do you know who was the victim of this type of abuse?
Oh, myself.
And how long ago was this?
3 years.
Now, again, the same type of question. If Alyssa's here looking at you, telling you about the abuse that she suffered, are you going to be able to listen to her critically, pay attention to the details she's saying, and keep separate what happened to you in the past?
Yes.
All right. Jurors number 7 and 10. Did either of you report to the police what happened to you?
No.
Juror number 7, again, this is one of those probing questions I have to ask. Why did you not end up telling the police about what happened?
I was just ashamed.
Juror number 10.
I was afraid.
What were you afraid of? Most broad terms.
Physical abuse.
Retaliation?
Yeah.
Does anyone here think that those are uncommon reasons someone wouldn't talk to the police about what happened to them? Would any of you be surprised to hear that someone who's been in domestic abuse didn't immediately leave their abuser after it happened? If you were to hear Alyssa tell you, she went back to him after the first time he put his hands on her, would any of you be less likely to believe her when she says he put his hands on her? Now, part of this trial is going to be judging credibility of witnesses. This isn't like, an embezzlement case or a retail fraud, shoplifting case where everything is very, let's call it, hammered down to stone. You can see the Excel spreadsheets of the receipts and transactions. You can see on video the items being taken. It's an assault case, and so a lot of it boils down to, do you believe the victim telling you I was assaulted? By show of hands, who here has children? Keep those hands raised for a minute and keep them raised if your child has never been dishonest with you. There's no way. Oh, you have the most honest child on this earth. I know this is taking it to very much, base level, but those very rare times I'm sure that your child wasn't honest with you fully, what kind of things did you look for in figuring out if they were being straight with you? Juror number 2. How'd you figure out if your kid's being honest?
My kids would start crying if they started lying, so I got lucky.
You know their tells.
Yeah.
Juror number 6.
Eye contact.
What about that?
That's usually the telltale sign they're not telling the truth, if they are, not look at me and or their mother in the eye. So
That's-
they're looking away.
That's absolutely fair. When your kids have, is that a fair tell that most people's kids have had, where they find it hard to look you in the eyes and lie to you? So that's one that basically everyone brings up, because that's what happens all the time. I find it very difficult to do that, especially if they know. Who here would be comfortable locking eyes with me and telling me in detail about their last time they had sex? Nobody. Imagine trying to do that when that sex act was against your will. A room full of strangers. They were expecting that it would be very easy for her to maintain that eye contact.
Yeah.
By the way, who here is having a comfortable experience now sitting in this jury box having a talk with me? No hands ever go up for that. All of this process is uncomfortable and awkward. Does anyone here think they would have an easier time if they were the person sitting in that witness stand? Does anyone think that there is a way that she should be acting when she tells you about the worst moments that have ever happened to her? So if you can't look for that, what would you look for to try and judge if she's being honest with you? Look at this one. Mr. Freeman brought up something about consistency. Don't here think that would be something that you'd look for. You know, if you're saying the same thing happened to you each different time. Yes?
Yes.
Okay. Who here has told the same story to multiple people in your life over the years? By choice. I mean, everybody, we're human. Has every detail of that story been the same every single time? Have the cores of that story been the same? The cores of that story been the same? Would anyone be shocked if that same type of thing happens in a trial that was years after the last time they told the story? I don't know, I can't remember. Don't you think that that would make it less likely she's telling you the truth if small things are different from last time?
There is a phone that keeps going off. I need to make sure that whoever it is, you turn it off, please. Thank you. We proceed.
If she's consistent every time you hit me, she just says a different hand. Does that make you believe that didn't happen?
No.
Does anyone here have a personal or strongly held religious belief that makes it difficult for you to judge someone else? You feel it's just not your place.
You say religious beliefs, sorry.
Strong personal or religious belief that makes it where you just feel it's not your position to judge someone else. Everybody okay? As I've already said, you as a jury are never going to get to see every piece of evidence. No jury ever has that's ever been on a case. I mean, it's part of how our country's legal system works. So it is the most fair and impartial view of the evidence that a jury can have. That means that there are things I'd love to have in. There's things the defense would love to have in every single case. And you're just never going to know that that exists. That's the goal. If everything's done well, you will never know what you don't know. If you believe that the evidence you've been presented proves guilt beyond a reasonable doubt, but you still wish you could have heard from, I'm truly pulling random things here. I wish I could have heard from the neighbor. I wish I could have heard from that Uber driver. I wish we could have seen that Ring doorbell footage. Yes, I think the evidence they've shown is enough to prove guilt beyond a reasonable doubt, but I wish we could have heard from blank person. Can you all still agree to make that decision based on what you have? If it's enough to come back with a verdict of guilty?
Yes.
Does anybody have any difficulty making that decision, knowing you're not going to know everything, you're not going to see everything, as long as it's enough to prove beyond a reasonable doubt? Is everybody comfortable with that concept?
Yes.
By that same token, you will not, by law, cannot know what the possible penalties are for these various crimes. That's by design. They want you making this judgment based on what you believe happened, what you believe the facts show happened, and not based on, well, you know, we'll agree to get rid of the big stuff and the little stuff and just split it down the middle with the medium things. That's why you're not allowed to know those things. You're not allowed to know what the possible penalties are. Because after your verdict, you come back guilty on these crimes, the judge will then get everything. The police report states every possible thing that could factor into what should happen. And she is the one who sentences someone. It's something in the gallery.
They're working on it.
We're trying to shut it down, can't figure out how to shut it off.
Brian, go ahead.
Yeah.
Maybe you can go in the hall for a moment. Brian can help you. Thank you.
Like I said, one of the most common kind of mental roadblocks that jurors have had in the past is, yes, I think it happened, but I don't know what the penalty will be. I had a trial where quite literally during deliberations, there were two jurors who just said, I don't know if I can. I don't know if I can make this decision. It's such a big thing. What kind of impact could it have on his life? I just don't know. And at that point, it is too late to be, you know, voicing those concerns. So that's why we have this here. Does anyone here feel that they're going to have any difficulty coming back with a verdict of guilty if they believe the evidence shows guilt and you just don't know what will happen as a result? All right. Show of hands. Who here has had interactions with law enforcement? All the new people. The new people. All agree. So I think that was 2, 6, and 10. Juror number 2, what interactions have you had with law enforcement in the past?
Just some traffic stops. They came to my house once to check on my ex-husband.
Ah.
Yeah.
I understand. Did anything about that make you biased for or against law enforcement?
No.
You going to be able to judge them as witnesses like anybody else working any other job?
Absolutely.
Juror number 6, what's your involvement with law
I was
enforcement?
a dispatcher at dispatch 1560.
Here?
Yeah, Bingham County, yeah.
Sorry, 2015 and 2016?
Yeah.
Okay, I didn't know if you meant like for 15 or 16
Oh,
years.
no.
Okay, I got you.
No, 15, yeah, 2015.
Okay. Now, to be clear, you've already heard the date ranges for these crimes. You don't know anything about this case,
No,
right?
or any of the names mentioned.
Perfect. Makes things easier.
Yeah.
Now, do you feel you can be impartial and fair to both sides in this case?
Yes.
Perfect. And juror number 10, what kind of experience have you had with law enforcement?
Trouble with my son.
So sorry. How long ago was he dealing with police?
Still,
Now, because of that, do you feel that the police are treating your son fairly?
sometimes.
Sometimes. Because of that, are you going to be able to sit and listen to officer testimony and view it like anybody else working any other job? Or is that just going to make it difficult for you?
To be honest, I don't think I could. I thought I could, but I don't think I can.
Hey, that is okay. Like I said, there aren't wrong answers here. I really do appreciate you being honest.
For 10,
You don't think you can listen to the instructions and sit through the whole trial?
I don't know, to be honest.
I don't think any juror really knows in any kind of case, because it's all tough. When you have to make a decision against your fellow citizens, it's a daunting task. Will you be able to listen and then will you note paper and take notes and then discuss the issues with your fellow jurors and reach a decision, or will it be too troubling for you to listen to, so you won't be able to do that?
To be honest, I can try. That's all I can say.
Have you ever been told you have trouble dealing with tough issues, or have you felt that you have trouble dealing with tough issues?
Yeah.
And how do you handle those?
Seen a therapist for that.
Okay, so this is something that might add on to whatever you have. That would be a concern. We don't want to cause you any additional trauma or whatever you're going through. So do you think this might add on to that?
I think so, because I can feel stress.
Okay, you're released. Any objection?
No.
No, Your Honor.
Thank you very much. Thank you, ma'am. You are now juror 10. Thank you, counsel.
Hi, I'm gonna rapid fire some of those questions at you before I get back to the rest of you. So, given the nature of this case, do you feel it's gonna make you so uncomfortable, you're not gonna be able to pay attention to what's being said? Have you, close friend, or family member to your knowledge been the victim of domestic abuse before?
Yes,
And who has it been?
myself,
How far back are we talking?
over 10 years.
Now, are you gonna be able to sit and listen to Alyssa tell you what she went through and keep apart what you had to go through?
Yes, I can.
Now, did you end up? I apologize, my mouth failed me there for a minute.
Yeah.
Did you ever end up reporting it to the police?
Yes,
And was that an easy thing for you to do?
no,
Why not?
I mean, you love someone, it's hard, even if you're wrong. It's hard to put someone in trouble that you care about.
Right. Show of hands. Anyone here think that it's uncommon to still love the person who's hurting you? No. If you were to hear Alyssa say that she had difficulty telling someone about what he did, that she had difficulty leaving him after what he did, would that make you believe her less when she tells you he hurt her?
No,
Now, apart from that, have you had any other interaction? And where you were as a victim or a defendant?
I was a victim.
I figured, but that is something I absolutely have to ask. Given what you went through, are you going to be able to listen to these types of crimes and be able to be impartial to what's going on?
Yes, I can.
Thank you. Now, you've already heard it said a bunch, and you're going to hear it said far more many times. That's because it is the bedrock of this system, reasonable doubt. Beyond a reasonable doubt is my burden I have to meet. And I have to meet it specifically for the elements of each crime, not all the other bits around those elements. Can you all agree to hold me to that burden and not every single possible little detail beyond a reasonable doubt?
Yes.
Now, one element that's in a lot of crimes, especially assault crimes, is intent. Did the defendant intend to cause great bodily harm, less than murder? Did he intend to strangle her? Did he intend to put his hands on her? That's different from motive. I don't have to prove motive, and you do not need to find motive. What you're asked is, does the evidence show he meant to do these things? He meant to put his hands on her. It wasn't an accident. He didn't trip and then accidentally keep himself up by her neck. Did he intend to hurt her? Not why. You are not asked to get inside the mind of someone who would hurt the person close to them. You are not asked to get inside their mind and figure out what could motivate them to violate another human being. What you are asked is, did he mean to do this? Does everyone here understand the difference between those two concepts?
Yes.
Can you agree to follow the law when it says, I don't have to prove the why, the motive?
Yes.
Like I said, beyond a reasonable doubt is my burden. The defense doesn't have any burden. They have rights. They have rights to a trial. They have rights to any witnesses they want, the subpoenas. They get the cops to help them get the subpoenas out. They have the right to all of my evidence, even things that aren't used at trial. See, I don't have those same rights. I am going to learn and am actively learning what the defense is at the same time you guys are. They already know what the charges are. But this is not about who presented more evidence. This is about who put on more witnesses. This is about, at the end of the day, just all the evidence prove guilt beyond a reasonable doubt. And you guys are well aware, there are a lot of charges here. There's 18 different ones. You are not required to find guilty on every single one to find guilty. You are not required to be an all or nothing thing. You are required to evaluate them individually. While I certainly believe the evidence is going to prove each crime beyond a reasonable doubt, if you disagree, and if you all believe, you know, he proved these 12 beyond a reasonable doubt, but these 4, I just don't think there was enough there. It's your job to come back with not guilty on those 4. Can you all agree? Can you all agree? Wow, no. Do you all understand that it's not an all or nothing prospect?
Yes.
Like I said before, specifically for sexual assault crimes, the law that the judge will give you is that the victim does not need to be corroborated in order to find someone guilty of sexual assault. If you believe them, you believe it proves guilt beyond a reasonable doubt, you could still listen to her critically, come away believing her and thinking, yeah, but this doesn't prove it beyond a reasonable doubt, for whatever reason. That's okay. But what the law says is, let's say the only charge here was sexual assault, nothing else. It'd be a much shorter, more straightforward trial, but let's say that's what happened. And the only thing I did was put Alyssa on the stand. And she tells you about how he raped her. And then when she's done testifying, I rest, I sit down, I put on absolutely nothing else. If you believe that her testimony proves that crime beyond a reasonable doubt, the law is you have to come back with a verdict of guilty. It's going to be way more that happens in this trial because it's not the one charge. But I bring that up because it's something that, you know, I exclusively do these types of cases. And it's something that a lot of jurors have a problem with. I want to believe her, but I need more. It doesn't matter what she says, I always need something else to back it up. But the law says for sex assault crimes, you don't. You believe it proves it beyond a reasonable doubt. Her testimony is all that you need. Does anyone here, does that make anyone uncomfortable being told you have to follow that law? Juror number 14.
Yeah.
What about that makes it uncomfortable or difficult for you?
I can see myself, kind of spinning out a little bit, if I feel like there's just someone's narrative and there's like literally nothing else, to go on. I think I would have trouble
Hey,
coming to a decision.
I understand that. There's a reason I asked this. So let me ask you this. Do you think it's possible for someone to rape their partner and not leave any marks?
Yes.
If that happens, what evidence would there be of the sexual assault?
I mean, just the person saying that, but I guess what I'm saying is that it's hard to tell what's evidence and what's not. I don't.
Or maybe what's credible?
Maybe, I mean, we don't.
Let's put it this way. If you listen to her, I'm not just saying, well, she said these words, therefore it ticks boxes. If you listen to her and evaluate her critically, not just, coming in if she says it is true. You're required to evaluate and judge every witness critically. And you come away believing beyond any reasonable doubt, this happened, he did. That's the only evidence presented at trial, is her words. Is that going to be enough for you to come back and verdict guilty, or will you still not be comfortable doing it?
I think I was actually doing that on this.
Okay. Look, I appreciate you telling me. The reason I ask these things is because they are a lot of times just basic human instincts sometimes. So I appreciate you being honest about that type of thing. I know it's not easy being in that box. I only have a couple more questions, and then I'll turn it over to Mr. Freeman. Does anyone here have any expectations about what a victim of domestic violence looks like? Does anyone here have any expectations about what a domestic abuser looks like? Does anyone here have any preconceived idea of how a victim of domestic violence would act on a witness stand? Can you all agree to follow the law as the judge gives it to you and apply it to the facts you are given at trial? And can you all agree to make your decision based solely on those two things, not anything else?
Yes.
Thank you. I have no further questions.
On behalf of defendants.
Yes, Your Honor, thank you. You're in seat number 13. You're with the Central Dispatcher in Ingham County.
I'm with Community Mental Health, so we provide behavioral health services in the Tri-County area. We're not county or state employees. We just have the authority from the counties to provide the services.
That's my error. I appreciate that. Thank you very much. You're in seat number 14. Given the answers that you gave just a few moments ago, would you want you on your jury?
I would do my best, but I mean, I know that I tend to have a very literal mind and sometimes I don't process things exactly the way other people do.
Ma'am, let me just stop you there for a minute.
Yeah.
When you have a very literal mind, there might be somebody else who has things differently. That's the great power of the jury, because with dissension, with disagreement, you all talk it out and you can reach a reasonable conclusion. Would you agree with that?
Yes.
Okay. And I know you have some worry about credibility or lack of credibility, but you have some common sense about you. I know you do, right? Would you agree that you have some common sense?
Yes.
Okay. So if do you sew it all?
Yeah.
Great. So if I took my robe and I took these scissors and cut around the bottom, you'd probably be able to tell that I cut the bottom 24 inches off, right, with scissors?
Yes.
The edges would be ragged, wouldn't be straight. But then if I told you that it got torn or shortened because it got caught in the door, what would you believe when you looked at the fabric? What would you expect to see?
Yes, I would see the fabric, but in that case, that example, you're showing me the fabric, you're not just having someone tell me the story of the fabric.
Okay.
Do you see the difference?
Yes, but I might also tell you, well, they wouldn't give me another robe, I really needed one, this was old and torn and tattered. And then I'm showing you this. It is very, I don't know the people's case, and maybe they can tell us if they have pictures. There's a police report, if we can't see it, I don't even get a copy. They've told you they have a few different witnesses, and granted, these things don't usually happen with eyewitnesses. But the victim tells her story, and then there's likely going to be other evidence. There might be torn clothing, scratches, bruises. Maybe she fell down the stairs because she's just clumsy. Maybe the bruise got there a different way. Do you think that if you listened to her testimony and see if it added up or didn't add up, you could make a decision?
I think so.
Okay. And let me just verify with the people. Is there other evidence that you will be presenting besides the alleged victim?
Yes.
Does that help you out, ma'am?
Yes, it does, thank you.
Thank you. Counsel, you may proceed.
Thank you, Your Honor. Juror in seat number 7. Dan Huckabee. In your opinion, are trials about the truth or finding the truth?
Yes.
Okay. And what makes you say that?
Well, like presenting evidence, I guess. I don't know.
It's not you, it's me. Pardon me?
Like when you present evidence or, you know, hear from witnesses.
Well, do you understand that while on the one hand you may receive some mileage money or something, you're not going to be paid a detective's salary for sitting in this jury?
Right.
You're not acting as a juror to try to solve something.
Right.
Okay? You listen to the evidence, you go back, these are the elements. Am I satisfied this element was proven beyond a reasonable doubt, and go down the list. If you get to one of the elements that's no, then you mark the box that says not guilty and go to the next one. And you still don't know what happened.
Right.
Does that persuade you to modify your opinion as to whether trials are designed to ferret out the truth?
Perhaps.
You're in seat number 10, a phlebotomist.
Correct.
And what functions do you take upon yourself other than drawing blood?
Well, we have to, there are cases where patients could be overwhelmed with the process. We do have patients that pass out, things of that nature. So we do have to make sure that we're comfortable looking at them in the face, those kinds of things.
I think you may have been here when I asked another person. I'm going to ask you, what is a bruise?
It's like a pool of blood underneath the skin.
And caused by some kind of trauma?
Yes.
Are you able to tell by looking how old a bruise is?
Yes.
And what's your understanding, just not with great particularity, just sort of a rule of thumb?
I'm sorry, can you repeat that?
Yeah, how would you go about estimating the age of a bruise?
The color, and also like the circumference of a bruise, because it is blood that pools. Sometimes when those vessels are healing, the blood will go back in. So like the size of the bruise too.
and this goes without saying, but I'm gonna say it anyway. Just by looking at the bruise, you couldn't tell what caused it. Okay. Someone could have a bruise, tell a story as to how it got there, and maybe it's a little bit exaggerated. On the other hand, as a medical person, is it also your experience that it could be plausible? Whatever story the patient is giving.
Yes.
Okay. Juror in seat 6.
Yes.
The judge is going to give all of you some instructions later. I don't want you to think that that's what I'm doing. Okay, I'm just asking a question. All right. You listen to what she says to the law is that you're to follow. Okay. But if you are, if you do hear this case and you're back in the deliberation room with 11 other folks, and all 11 want to vote one way, and you're just not there, I'm going to ask you 2 questions. Could you have an open mind to listen to the other 11? And if you're not satisfied, could you stick to your guns, as it were?
Yes to both, absolutely. Yeah, I could have an open mind, but if I still don't feel that the prosecutors have proven a reasonable doubt, absolutely not. I won't change my mind. No.
All right, thank you. During seat number 5, do you agree or disagree with what that gentleman just said?
Yeah, I agree that we have disagreements all the time.
Oh, heavens, yes, sure.
And, sometimes you have to stick to your guns if you're really in certain.
Yeah, that's my long way to go around the issue of whether you could hold true to what you believe, or whether, you know what, it's just easier that it has to be a unanimous verdict. I'm the only one. You know what I mean?
Yeah.
It's time to go.
Yeah.
All right. During seat number 4, let me ask you a little bit different. Oh, excuse me. I don't know that you're 7, 10. I'm just trying. Who was the most recent to sit? Yes. Okay. You're in seat number 2, please. Could you agree or disagree that functioning as a juror is not something that you're supposed to try to solve a crime or figure something out?
I agree. It's not up to me to solve it. It's up to me to listen to the evidence and then decide if, like you guys have said, all of the boxes are checked.
Yeah, could you accept the fact that law enforcement did an investigation and that concluded some time ago? That there's no need for you to sort of investigate?
Yeah, I don't think I could investigate.
Okay, good. You're in seat number 1. Question I have for you is, if you're in the jury deliberation room with the others, and the first person that you hear speak says, well, I think he did it. Does that sound like proof beyond a reasonable doubt to you?
No.
Okay. Would you be comfortable questioning your fellow jurors? Why do you think that? What did you hear that I didn't?
Yeah, I want to know what made that choice.
Okay, thank you. I'm certain that Judge Aquilina is going to allow note taking by you folks in the jury box. And is that something you'd be interested in doing? Seat number 1?
Yeah.
Okay. Thank you very much, Your Honor.
On behalf of the people for cause,
None for cause, but when it's defense's turn to lead.
not when I issue my down the list, so. For cause,
No, Your Honor, no cause.
peremptory,
People would like to thank and excuse jurors number 11 and 14.
thank you very much. On behalf of defendant peremptory,
Yes, Your Honor, thank you. The defense would like to thank, yet again, respectfully, excuse jurors 2, 8, and 13.
thank you.
Thank you, Your Honor. Good afternoon. Once again, these questions are going to be just for the people who have been recently added. You're going to see this process does tend to speed up and kind of snowball as it goes, whittle down further and further. So, all the new people who entered. Did you all hear the questions that have already been asked by myself and the defense counsel? Big, loud? Yes. All right. Gotta kind of, get you loose and ready to talk, maybe not sitting back there. Is there anything that you heard us talk about that you have a very strong belief on one way or the other that you think we should know about? No. Okay. Given the graphic nature of this type of case and the testimony that's going to happen in this case, do any of you feel they're going to be so uncomfortable with it that's going to make it difficult for you to pay attention and fully listen to what's being said? Has anyone here, either yourselves or a close friend or family member that you know of, been the victim of domestic or sexual abuse? I think show of hands was 2, so juror number 13, who do you know who's gone through something like that? And it's like, how long ago was that?
5 years.
Was that something that ended up going to the police or to the court system? As her mother, did you want her to report what happened to her?
Not necessarily. No, I thought that was her decision.
Did you, that's the wrong way to say that. Did you understand the decision that she made or accepted? Okay. Now, given that you would hear testimony of crimes in the same vein as that, would you be able to listen to Alyssa tell you what happened to her and keep separate what happened to your daughter?
Yeah, yes.
Be able to still be fair and impartial, based on the evidence here and not based on what your daughter had to endure?
Yes.
Thank you. Juror number 14, who do you know that's been the victim of this type of abuse?
Myself.
And how long ago was that?
About 3-4 years ago.
Now, did you end up reporting to the police what happened to you? Was that easy to do?
No.
Did that end up with charges or a criminal case? Are you going to be able to listen to Alyssa tell you what happened to her and keep separate what happened to you? By show of hands, who of the recent additions has had police interaction? Just for sake of time, we'll say beyond a traffic ticket, speeding ticket. Okay, juror number 8. And what type of police interaction have you had?
Oh, my best friend's he's a cop.
Where at?
And, well, he's retired as a sergeant from Manistee, but he's a fed now working for one of the Indian tribes.
Oh.
Up north. And I don't know any cops that you mentioned earlier on this.
That beats me to the punch for my next one. Are you going to be able to listen to officer testimony and, view it, weigh it as you would anybody else's testimony in any other profession?
Yes.
Okay. The goal is you judge the person's credibility, not the credibility of how they get paid. Is that safe to say you guys can do that? Does anyone here think that they have any strong personal or religious belief that makes it difficult for you to just sit in judgment of your fellow man? No. Juror number 2. Part of every trial is that you do not know what the possible penalty is for these crimes. If you believe the evidence shows guilt beyond a reasonable doubt, are you still going to be able to come back with a verdict of guilty, even though you don't know what the possible penalty the judge may give? Yes. Does anyone here have any difficulty deciding guilt or not guilt because of the possible penalties? No. Like I said, you're judging whether or not I have provided enough evidence to prove guilt beyond a reasonable doubt for each element of these crimes. Can you all agree to hold me to that standard and make me do my job?
Yes.
Does anyone here have any trouble telling me to my face I did not do my job?
No problem.
Perfect. Now, that standard is just to the elements, not to all the extra details that are around those elements. You all agree to not hold me past what I'm required to do here. You all agree it's not about what fist was used, just that she was hit. The judge is going to instruct you what the law is. I do not say what the law is. Mr. Freeman does not say what the law is. None of the witnesses say what the law is. I might try and beat judge to the punch and quote the jury instructions, but what I say isn't the final word. What Judge Aquilina tells you the law is, that is the final word. Can you all agree to follow the law as Judge Aquilina gives it to you, even if you may not agree with it personally?
Yes.
As I've said, you're not going to get to see everything in a case. You'll never get to see every piece of evidence in a trial. I know I'm saying this for like the 4th time now, but that's because it's pretty important. Does anyone here have an issue deciding guilt, knowing you're not going to see everything that exists about these crimes? Juror number 8.
I don't know. I'm having a little bit trouble with the timing of it.
In what way?
I mean, well, I can't remember exactly, but it sounded like these charges started in 2018. They made it all the way up to 2024. Now it's 2026.
So, part of what you'll hear Alyssa say is that she did not immediately report what happened to her. And that it took her a bit to actually tell the cops in detail about the various crimes he committed, particularly the older assaults and it was 2020. Does hearing her say that does it make it harder for you to believe her when she says that these crimes did happen to her?
No, I understand it would be difficult to come out right away, but I also know, for example, Duke University, the lady lied about the men's lacrosse team, that she was gang raped, and then there was a lot of trouble that came through, and then it found out a couple years later that she did lie about it. So when it takes a long time, makes me wonder. My brother was in an abusive marriage, and within 3 years, he's like, okay, I've tried my best to resolve it. I had to move on. But how much time do you have to give somebody? Do you know what I mean?
That's for you to determine. The length of time is not an element, but that goes to the credibility or incredibility that you will all determine.
Can you say that again, ma'am?
Yes, length of time that this took, the span that you're talking about is not an element. Okay, there's nothing that says it has to happen in this amount of time or reported in this amount of time. What it goes to is the credibility of the evidence and the testimony, which you are the trier of fact. I determine what the law is. You decide what is credible or incredible. Can you listen to the estimate, the testimony, the evidence, and then determine what's credible and what's not?
Of course.
Thank you.
So to that point, what reason can you think of why a woman would wait to report what had happened to her in domestic abuse?
Are you asking me still?
Yeah.
Well, I mean, I'm sure there's some humiliation that goes along with that. I mean,
Is there any other potential reasons that come to mind just immediately for you when you're thinking about this type of situation?
one more time with the question.
Sure. So are there any other reasons that immediately jump to mind for you personally as to why a woman might not immediately report or maybe never report what happened to her?
I'm not a woman, so I don't know. I mean, as a man, I would, defend my position or defend, try to resolve something in a certain amount of time, like that, for example, in my brother's case. So
Okay.
I can't speak for what a woman thinks. I'm not a woman.
Okay.
I don't mean
So-
sexist, I'm just being.
No, it's fair. You're not, I'm not. But then, can you see why it would be maybe not the most perfect analogy comparing what took for your brother, a man, to come forward versus a woman? If, like you said, you're not a woman, you don't know reasons why. Can you see why that might not be the most perfect comparison to make?
Sure.
Would anyone here would it make you less likely to believe her if she tells you that she went back to him after he had beaten her? Show of hands. Does anybody here believe that that is cause to not believe her, that she went back to her abuser? Nobody. Does anyone here have any expectations about what a victim of abuse would look like? Does anyone here have any expectations of how a victim of prolonged abuse would respond to that abuse? Who's ever heard fight, flight, or freeze? How about the fourth one? Fight, flight, fear, or fawn?
Or what?
Freeze or fawn. F-A-W-N. Trying to be affectionate and loving because that might avoid further beatings. Does anyone here have any expectation of how she should have responded to this prolonged abuse? Or what she should have done in response to it? If she did not respond to it in a way that you like, or you approve of, or think should have happened, are you going to hold that against her? Does anyone here think that you can be raped by your partner? Does everyone here think it's possible to be raped by someone that you have had consensual sex with before? Yes. Anyone here think it would be easy to talk about that in front of an open courtroom, in front of the person who raped you? Does anyone have any expectations of how she should be acting on that witness stand while talking about her rape in front of her rapist? No. Does anyone here feel I have to have a certain type of evidence to show you in order to convict on these charges? Does anyone here feel I have to have an eyewitness? Does anyone here feel I have to have the crime on video? Or that I have to have DNA evidence to show you? No. Are any of you going to require that of me in order to find guilt here? No. Can you all agree to follow the law as Judge Aquilina gives it to you and apply it to the evidence you get from that witness stand from the exhibits? Yes. Is there any reason you guys can think of as to why you would not be a good fit to serve on this jury? Okay, I have no further questions, Judge.
Thank you. On behalf of the defendant?
Yes, Your Honor, thank you very much.
To start with the lady in seat number 14. I heard most of what you said when you answered counsel's question, but not all of it. You were a victim of crime, is that what you told us?
Yes.
Okay, and it was of a sexual assault of some kind?
Physical, sexual.
Okay. But what was interesting to me is I also thought I heard you say that it was not reported to law enforcement, no action was taken.
I didn't report it, but somebody else did.
And did law enforcement got involved?
Yeah, but it wasn't taken to court or anything like that. I didn't press charges.
Thank you. And the reason I'm asking these questions is because you can appreciate my client and I, neither of us would want you to be a juror in this case, thinking, I'm going to make up for that. I'm going to convict this fellow because no one was ever tried or convicted in my case.
Right, we never had a case.
Did you have any complaints about law enforcement and their conduct and their investigation in your case? And I think counsel asked you, but I'm going to ask it slightly differently. Is there anything about your experience that you would feel as though you should bring with you to the deliberation room, share with other people?
No, that's separate.
You're in seat number 8. How can anyone prove a negative?
Can't prove a negative.
So one person can say this happened, this happened, this happened, and the other person can't prove it didn't. Fair?
That's true.
During seat number 13, I asked this of someone else. I'd like to ask you if you don't mind. You appreciate, of course, that you're not going to be paid a detective's salary if you're on the jury, right? And are you of the opinion that jurors are supposed to solve crimes?
Can you word that again?
Is it your understanding that jurors are, your duty would be to solve a crime?
No.
Thank you. On the other hand, is it your understanding that you simply take the evidence that you've seen, that you've heard from the trial with you to the deliberation room? And if the judge reads you the law the way I believe it's going to come in, it would say you don't have to leave your common sense out on the street.
Yes.
Does that make sense to you?
Yes.
Just from life, human behaviors. Juror in seat number 11, what does beyond a reasonable doubt mean to you, sir?
Probably more likely than not.
All right, let me put it this way. I want you to just imagine, just making a point. I want you to put the deed to your house up there on that railing. I want you to put your 401k up on that railing. I want you to put all the money in the savings account up on that railing. And then go vote. We secretly have a video of the entire situation. And if you vote incorrectly, that's all mine. How confident are you in placing your vote if those were the potential consequences?
I'd still be confident.
Beyond a reasonable doubt, a judge will tell you, but it means not precise, exact, ultimate certainty, but pretty doggone close. It's Could you accept the fact that beyond a reasonable doubt is not more likely than not?
I think I'm confused by the wording just a little bit. Sorry.
Yeah. Me too. Has to do with the degree of certainty in making a judgment decision. Would you agree with me? Most folks wouldn't take stock advice from an 8-year-old.
Correct.
Okay? And it's not whether you believe the 8-year-old, maybe you do, but is it reliable? You walking with me?
Yes.
Okay. Because I don't believe the word believe is in any of the instructions. I think it all has to do with whether testimony is sufficient to persuade or convince you beyond a reasonable doubt. Nothing to do with believing. Is it reliable? Is that consistent with what your understanding is?
Yes.
Sir?
Yes.
Okay, thank you very much. Thank you, Your Honor.
On behalf of the people for cause,
None for cause, Your Honor.
on behalf of the defendant for cause,
No, Your Honor, thank you.
on behalf of the people for injury.
People would like to thank and excuse juror number 8.
Thank you. On behalf of the defendant,
Yes, Your Honor, thank you. The defense would like to thank and respectfully excuse jurors 8 and 2. please.
8 was already excused by the people, so the other one is 2.
Yes, Judge.
All right.
And if I may.
May.
I was 8 and 10. Please. What?
8 and 10 or 2? You said 8 and 2. Is it 2 and 10? 8 was already excused by the people.
Yes, and therefore 10 and 2 would be.
10 and 2. Okay, thank you very much.
Thank you for that correction.
No problem. On behalf of, let's see, clerk, yep, here she is, juror seat 8.
Full sequence number 341.
Good afternoon. See, less and less each time. Now, were you all able to hear the questions that myself and the defense attorney asked many, many times now? All right. Big loud, yes or no?
Yes.
Yes. All right. Now, do any of you have a really strong belief about what we've touched on so far that you feel you want us to know? It's important in potentially serving as a juror. Okay. There's 3 of you. I can actually just call individually now. This is so much worse for you. All right, now it's just cold call. Juror number 10. Now, the nature of this case is unfortunate to say the least and pretty graphic. Are you going to be able to sit and listen to Alyssa talk about that type of detail without being so uncomfortable that you're not able to pay attention to what she's saying?
Yes.
Number 2, juror number 8. You guys agree? You guys listen to what she's saying despite the discomfort?
Yes.
Now, show of hands. Have either yourselves, close friend, or a family member that you know of been the victim of either domestic abuse or sexual abuse? Okay. Juror number 8. Who do you know who's been abused like this?
My wife and private girlfriend.
And how far back is what happened to your wife?
Probably 20 years ago prior to us getting married.
So it's before you knew her, is that safe to say?
Yes.
Now, are you going to be able to listen to what Alyssa tells you happened to her and keep separate what's happened to the women you've known?
Yes.
Are you going to be able to be fair and impartial for this?
Yes.
Juror number 2, who do you know who's been abused before?
My mother-in-law, about 25 years ago, in marriage to my husband's biological father.
And are you going to be able to listen to what Alyssa tells you and keep separate what happened to your mother-in-law?
Yes.
You going to be able to be fair and impartial to both sides in this trial?
Yes.
Have any of you, either yourselves, close friend, or family member, been accused of any such crime like this before? To your knowledge? No. Have any of you had police interaction before beyond just standard speeding traffic tickets? Oh, everybody. All right, juror number 2.
My husband's uncle is the chief of police Spring Arbor, and my husband's grandpa was a former dive officer and FBI.
Sorry, you said what officer?
The dive.
Oh, okay. I didn't hear it right the first time at all.
I don't know the correct term.
I understood what you meant. Are you gonna be able to be impartial to the police witnesses and not give them more or less credibility based on where they get their paycheck from?
Yes.
Juror number 8, what type of police interactions have you had?
My cousin is a retired inspector from the state police. I'm retired, but I was 31 years in corrections.
Which one? Or what facility did you move all over?
No, I started in Kalamazoo as a probation officer for about 1.5 years, 6.5 years as a parole officer, 4 years representing the state parole violation hearings, and then, and don't hate me, Judge, I oversaw Compass for the state.
You saw what?
Compass.
Are you going to be able to be fair and impartial and just base your decision on the evidence you receive and not, the fact that it's the people on one side or that people are calling police witnesses?
Yes.
Juror number 10, what police interactions have you had?
In the past 4 months, I've had 2 cars stolen, so I've dealt with the police because of that.
Fair. How was your interactions with them at that time? Do you feel like they helped you or they let you down?
They helped me.
Glad to hear it. Now, with that being said, with police witnesses here, are you going to be able to be fair and impartial to the police witnesses and not, give them more or less weight based on what they do for a living?
Yes.
All right, perfect. Now, you are not going to be told what the possible penalties are. Some of you with experience might be able to hazard a guess, high, but you're not going to be told what the possible penalties are for these crimes. That's because you're supposed to be judging solely on the evidence and not worried about what could happen as a result. Does anyone here believe they're going to have any difficulty coming back with a verdict of guilty simply because you're not sure what's going to happen?
No.
All right. Does anyone here have any strong personal or religious belief that makes it difficult for you to stand in judgment of somebody else? Juror number 2. The standard here is reasonable, beyond a reasonable doubt. And it only applies to the elements of the crimes, not to all the extraneous details around those crimes. Can you agree to hold me to that standard?
Yes.
Can you agree that, pledge to me that if I don't do my job, you're gonna come back with not guilty?
Yes.
8, jurors 10. Can you guys follow her in that? In pledging, you will hold me accountable if I don't do my job.
Yes.
Perfect. Now, like I said, the judge is the person who tells you what the law is. She is the decider on the law. You apply the law given to the facts you get from the witness stand and from the exhibits. You see, doesn't it go beyond a reasonable doubt? And because that word gets thrown around a lot, I want to be really clear here about what reasonable doubt is defined as in the law, because I get a preview of what she'll tell you. And what it says is that a reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on a reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of the case. Does anyone here think they would have difficulty in deciding what in your head is a reasonable doubt versus an unreasonable one?
No.
There's a little thought in the back of your head that says this is all a big government conspiracy. You're gonna call that an unreasonable doubt? Please say yes to that. Okay, good. Now, if you do not agree with the law as Judge Aquilina gives it to you, you just personally, I don't think that's how the law should be. I don't think that that's what the crime should be. I don't think that's what X should be. You all agree to kind of ignore that personal belief during this trial and go solely off what Judge Aquilina tells you the law is?
Yes.
Do any of you believe it? Does any of you find it strange that a victim of domestic abuse would go back to their abuser?
No.
Is anyone here surprised or concerned that a victim wouldn't immediately report what happened to them?
No.
Would any of you be surprised if a victim never reported what happened to them? If she tells you, I didn't report it for blank amount of time, I didn't report it for several years, does that make you less likely to believe her when she says, this happened to me? Does everyone here agree that you can be raped by someone you have been previously having consensual sex with?
Yes.
Does everyone here agree it's not possible to consent if you're unconscious?
Yes.
Does everyone here agree to base their decision on the evidence and not on who you like more or dislike more?
Yes.
Yes.
As I've said, you're never going to get to see every piece of evidence in the case. Ever. No jury ever has for as long as we have had a justice system in this country. Knowing that you're not going to get to see everything and still being asked to make this call, are you confident you'll be able to make this call based on what you're given?
Yes.
And it's been brought up the analogy of you're not detectives, you're not solving crimes. It's true, but your job is to decide what did happen. Does the evidence show this is what happened beyond a reasonable doubt based on what you're given? Can you all be confident that you're able to make that call, to make that decision?
Yes.
Can any of you think any reason why you may not be a good fit to serve on this jury?
No.
Okay. And with that, I have no further questions.
On behalf of the defendant,
Yes, Your Honor, thank you. Any of the questions I posed earlier with respect to residency and other qualifications to sit on a jury in this county, any reactions from the folks?
No.
I see no hands, thank you. German seat number 2. If your residency was challenged, in other words, I don't think you lived there, what might you do or show to the contrary that, yes, I do live there?
I would provide the deed to my house, the bills that I pay for my home, my belongings in the homestead. My phone has a tracker in it, I'm sure that it's able to be seen.
If you had that address on a piece of personal identification, would you think that's significant to show residency?
Yes.
Thank you. And you spoke of personal belongings. Let me follow up just briefly. Even if there was a second or a third person living in the same household, nevertheless, could you identify personal items that are yours and yours alone?
Yes.
Okay. And again, that would be to show that, why are they in this house? It's because I live here. That sort of just makes common sense, but I'm asking you, does that make sense to you?
Yes.
Thank you again. You're in seat number 8. If you have an opinion, if you can answer, on the other hand, if not, that's fine too. Do you have an opinion as to whether phrases like, I'll kill him, I'll kill you, I could have killed you, this word kill, doesn't necessarily and automatically ring of actually extinguishing someone's life?
True, I guess it'd be all, what's the context, what's the situation?
Sure, of course. But the words themselves don't necessarily and automatically.
No.
Okay. Thank you. You're in seat number 10. You've heard this phrase, actions speak louder than words.
Yes.
What does that mean to you, sir?
Action speaks louder than words. It means you're doing what you're saying.
All right. So if the testimony from a witness was, I have never been more scared in my life than I was at that moment. And the next question is, well, what did you do? I went out in the kitchen, made a sandwich, and finished watching the ball game. If the words don't match the behaviors, which do you lean toward?
I don't know.
Okay. Thank you. I'll ask then, juror back in seat number 2. Did you, actions speak louder than words? You've heard of that.
Yes.
All right. So does that mean to you that if someone says something, it does something entirely different? The words weren't really important. It's what someone does. Is that fair?
I think both are important, but context plays into what seems truthful.
Thank you. Yes, juror, seat number 8 again, please. I believe that there's going to be some evidence of some profanity, name calling, whether through text messages or some other medium that have been preserved and that I think you're going to see. And my question is, if one person is upset, swearing, calling names, does that automatically or necessarily mean, in your view, that an allegation of assaultive behavior necessarily follows?
No.
Thank you. Thank you, Your Honor, and that's all I have.
Your Honor,
Yes.
unfortunately, you asked this question early on, but 31 years in corrections, unfortunately, I'm already seeing what the prosecution is going to go, their tack and the defense tack.
So you're starting to form decisions already?
I am, unfortunately.
And you're not going to be able to unwind them, paying attention to the evidence, or?
Again, I think it'd be difficult based on my career.
I would agree with you, sir. Any objection?
No, Your Honor.
No, Your Honor, thank you.
Appreciate you raising that. Sir, you are excused. As to juror seat 8.
Pool sequence number 246.
Thank you. We just can't seem to fill number 8. I'm not sure if we should play that number in the lottery or avoid it. So, all right, thank you, sir. Counsel, would you like to?
Do we want to do the round of challenges first before you?
That's fine. For cause?
None for cause, Your Honor.
For cause?
None, Your Honor.
Peremptory?
None.
Peremptory?
Thank you, Your Honor. Jurors in seats 13 and 14, please.
Thank you. As to juror seat 13.
Pool sequence number 297.
Can we approach very briefly?
Yes.
Good afternoon. Again, I gotta do that, otherwise you just never want to talk once you're in the box. Okay. First. You good? Okay. You've heard us talking for a while now. I'm gonna be asking a lot of these questions again, because I have to earn my paycheck somehow. But is there anything we talked about that you have a very strong personal belief about that you think we should know when serving as a juror? No. Okay. Now, juror 13. This is going to be a difficult trial to sit through, not just because of the number of charges, but because of what those charges are and the graphic nature. Are you going to be able to listen thoroughly to what's being said to you, despite how uncomfortable it might be?
That's, as the days progress and you keep asking that question, that's one that with 2 young adult daughters and going through and having girlfriends and going through this, it's I'm definitely worried about that. But I think I can do it, but that's definitely the one piece.
Okay, that's all we ask of you. All we ask is you be as honest as you can, be as self-reflective as you're capable of being. Juror number 14, how about you? You can be able to sit through it? You can be able to sit through it and listen to that type of evidence? Juror number 8?
I can sit through it.
Okay. Now, have any of you, either yourselves, friends, or close friends or family members that you know of been victims of sexual or domestic abuse? Okay. Now, you've heard several jurors talk already about how they were victims and how many of them didn't go forward. You hear Alyssa say, I went back to my abuser, I didn't report what happened to me for years. Does that make any of you less likely to believe her when she says that abuse happened? No. Does anyone here any of you three have a preconception of what a victim looks like, how a victim should act when they're being abused? I know the example is used of, well, if I say I was scared, then I went and got a sandwich and sat down on the couch, what to look at. If you were to hear, I went, made a sandwich and came back to the couch because I was afraid I would get beaten if I didn't. Does that make you believe her when she says she was scared? Yeah. Even though she went and got the sandwich and came back to the couch? I think it was juror 2 who said it, but context really matters for that, right? Any of you feel like you're going to have any difficulty judging credibility of witnesses on that witness stand, serving as a juror?
No.
Does anyone here have any prior law enforcement interactions or friends or family who are in law enforcement? Juror number 13, who do you know?
Don't know, but had interactions when I was younger in college. So had a couple arrests and that's some time. So
do you feel you were treated fairly?
For the most part, yes.
For the most part. I think that's fair.
Yes, because I did make the mistake, so I totally get what they were doing.
I never did mistakes in college. Are you going to be able to listen to the police testify and view them? I mean, frankly, judge the credibility as people, not as professions. Juror 8, 14, do either of you think you're going to have any difficulty viewing them as people and not as badges?
No. No.
Great. By design, you're not supposed to know what the possible penalties are for these crimes. Do you feel you're going to have any difficulty or hesitation coming back with a verdict of guilty simply because you don't know what might happen as a result of that? No. You're also not going to see every piece of evidence because every piece of evidence can't be admitted in a trial because of various different rules of evidence. Are you are you confident that you can make this decision based on the evidence you have at the end of the day and not the evidence you wish you had?
Yes. Yes.
Juror number 14. Can you agree to follow the law as the judge gives it to you?
Yes.
Can you agree to ignore what I or the defense attorney say the law is and rely solely on what the judge says the law is?
Essentially.
Perfect. Now, as we've said many times, the defendant does not have any burdens in a trial. Literally, that entire table could take some well-deserved rest and sleep throughout all of it. And if I don't do my job, it's your duty as a juror to come back with a verdict of not guilty. Can you all agree to hold me to my task?
Absolutely, yes.
The defendant also has the right to not testify. If he chooses to go by his Fifth Amendment right that we all have, can you agree that is not to factor into your deliberations at all? In sexual assault cases, part of the law is that the victim's testimony does not need to be corroborated to find someone guilty. That's because of the very intimate, private nature that is sex assault crimes. But it makes a lot of people uncomfortable. We've already seen that because, we're human. If the only thing you hear about the sexual assault is what she tells you, what she describes happening, and you come away believing it beyond a reasonable doubt. You believe it shows that crime happened beyond a reasonable doubt. That's all I do. Are you going to abide by the law and come back with a verdict of guilt?
Yes. Yes.
Again, these crimes have to be proven beyond a reasonable doubt to the elements, not everything else. I use the example every time of proving that there was an assault, not which hand was used. That's because it's the best one I can think of. Can you all agree to hold me to the burden of proving the elements beyond a reasonable doubt and not every single factor or thing that happened around it?
Yes, yes.
Court is not like TV shows, and investigations are not like TV shows. It's not like CSI, it's not like Suits or anything along those lines. There's not going to be some big dramatic reveal or bombshell witness that comes to the door. There's not going to be zoomed in DNA fingerprint analysis or anything like that. Is anybody going to hold me to that expectation that it's going to be like TV?
No.
Is anyone here going to think, wow, they didn't have, there's not enough there because there wasn't some big bombshell reveal? Does anyone here think there's always eyewitnesses to crimes?
No.
Apart from the person who committed it and the person it was done to? Can you all agree to follow the law as the judge gives it and apply it to the facts that you get in this case?
Yes.
Yes.
Last question I have, juror number 8. I'll harp on this a bit more because it's important. You're picked to serve on this jury. Back in deliberations, and a fellow juror says to you, I think the evidence proved this beyond a reasonable doubt, but I wish we could have heard from the Uber driver. What are you going to tell that juror?
I mean, it's only we look at the evidence that was given to us that we're able to see that you're giving us to you're on the case, not outside evidence.
Fantastic. One of the last things I will say, I'm going to quote a former juror from one of the other trials, but she said it best and I could not top it. You are not supposed to commit clean slates. You're supposed to use your common sense and your judgment. And what she told me was, how she described it to me was, the evidence took me to here, and my common sense took me to the extra last step. You are supposed to be humans in there, thinking, feeling, and talking with each other. Supposed to hold to convictions, but also not be so blinded by them that you're not engaging with your fellow jurors. It is deliberations for reason and not just a straight vote, well, that's where we're at. Can you all agree to deliberate with each other, to be open and honest with each other as jurors?
Yes.
Yes.
Your Honor, I have no further questions.
On behalf of the defendant,
Yes, Your Honor, thank you very much. Prospective juror in seat number 14. You indicated on your form that you're a scientist?
I'm a retired scientist, worked at drinking water laboratory.
Thank you very much. Any work in the Michigan Department of State Police Crime Laboratories? Okay. And sitting next to your juror, number 13, what is a director of data?
So I lead a team in creating databases and creating cloud databases, and then from there we create reports from it to help drive the business, to show us where our profits are, to show us how we can get there.
Do you work for the government or a private agency?
Private.
Oh, okay. Was there anything about any of the questions that you've heard me ask others that you would have responded to?
Can't think of
Would you agree that you can't really prove a negative?
You can't really prove what?
A negative.
I don't know.
How could you possibly prove that you were not in Los Angeles, California last weekend? How could you prove that you were not there? You'd have to prove that you were somewhere else.
Right.
Prove the positive. Okay. So it's well, virtually impossible for someone to prove a negative. I did not do something. Does it meet with your understanding of life generally?
Yes.
Okay, thank you. And back to the gentleman in seat 14. Were there any of the other questions that you would have responded to that you said, hey, that applies to me?
Yeah.
Any reason at all why you can't be fair and impartial in this trial? And the last thing before I sit down, I'm going to ask both of you to look up and down the road. Do you know anybody else who's up there right now? Okay, thank you, Your Honor.
on behalf of the people for cause,
None for cause, Your Honor.
on behalf of the defendant for cause,
None for cause,
on
thank you.
behalf of the people peremptory.
None, Your Honor.
Thank you. On behalf of defendant,
Yes, Your Honor, 20 seconds, please.
thank you.
We're satisfied, Your Honor.
We have a jury. All right, so for the rest of you, thank you for spending your day with us. This is Friday, so you no longer have to call in, and you're good for 1 year, so I'll see you next year. Have a wonderful weekend. Thank you. All right, for the rest of you, Monday, we will work from about 9 until 3 o'clock. Monday, there'll be a shorter lunch. We'll be buying your lunch because we want to make the most of the day. Before I release you to Brian, who's going to show you how to come in and where the jury room is, I just want to give you some brief instructions. I will read you a set of instructions as I did today, but I need to go over some things. I will not impanel you, swear you again until Monday morning, when I will swear you in during the instructions I read to you. First of all, and foremost, this is not a homework class.
No research, Googling, don't brush up on legal terms, nothing. If there is a legal term or medical term or anything else we want you to know, the lawyers will present it to you when we were all here on this case, so no homework. For those of you who read the newspaper, the radio, the television, follow up on the news, like my mother had news on every television and radio that she ever entered. And my father scanned every single corner of all the newspapers. If you're like that, please set down the newspaper, read the Meyer advertisements or Kroger's, read other things, but not politics, but nothing in regard to the crime in the city. The media, I'm always surprised at what they report on. And I'm here every day, I don't always know they're here. They may sit in the back, they also may be on Zoom. They report. I usually hear that they've been here because somebody sent me an article saying, asking me a question about what just appeared in front of me or whatever. They send it to me and say, there you are again, or something. That's how I find out. So I can't even tell you they're here. So I don't know whether this story is going to be in the newspaper or not. No idea. So please, don't listen to the local news. Don't read it. Don't, if the radio turns on and they have those little blips about what's going on in our community, please don't listen. Put the station to music. You cannot get any information from any source except this courtroom. Additionally, your family, coworkers, friends, spouses, children, you can tell anybody you want that you have been selected for a jury, but not what courtroom. Because what they will do ultimately is go on my docket, look at the case, look at whatever they want to, because it's all on the line, online now. They'll figure out who you're in front of and what the case is, and then they're going to give you their opinions. Because they think that matters and it's important that they weigh in on what your job is. The answer is no. The only one in charge of this is you. You determine what the facts are from the evidence in this case. What they tell you or want to tell you cannot be allowed. And if that does happen, if someone tries to tell you information, we need to hear about it. You are not allowed to discuss this case until the time comes for me to tell you that you're going to go back there, read your notes, use your collective memories, and decide on this case. We've given you locations, a couple of different locations, as I read the felony information. Do not drive by or Google or research them or any names of any witnesses. You have juror stickers there. There are plenty in the back. Take some home with you. If you wear a jacket, I need that juror sticker on your jacket. I need it on your shirt. Have an extra one in your pocket because some fabrics, they fall off. Police officers are famous for doing this. We try to remind them, but sometimes they have so many cases and sometimes they'll meet another officer by the elevators and as they're standing, oh, what case are you here on? What are you doing? What do you think? If you are standing by a witness or by a police officer who you think is talking about this case, show them your juror sticker and tell them to stop talking. If someone doesn't stop talking, please report that to us at once. And if you do overhear something or think you've overheard something, please advise us at once. Counsel and I cannot talk to you. So if I see you in church or Myers or I don't know, the farmer's market, you see any of us, we cannot talk to you. We can't even say hello because it would give the appearance that we are talking about the case. So after the case is over, stop me at Myers or the farmer's market or church or stop counsel, they'll be happy to talk with you, but until the case is over, we simply can't talk to you. Wear layers. I don't know if you've noticed it. I'm in this robe, so I can't tell if it's hot or cold. I'm usually running warm because this robe is like, imagine wearing a robe all day over your clothes. It gets really warm under this robe. So I always have some ice water. Sometimes though it's really chilly in here. So I usually also have some coffee. So I would dress in layers. You can bring a cup with a lid and drink whatever you want as long as it's non-alcoholic. You can eat what you want, but no tainted gummies, okay?